That's that's the heart of the submission I'm making. In other words, if you have on the one side no discernible irreparable harm on the part of the decision maker, whether it's the speaker or the public protector or the president or whatever, that's irrelevant. But on the other side, you have these types of harm. Then it says the potential consequences thereof. Therefore, it should be held in abeyance until the review is completed. So that's the gist of what is said here. But thirdly, my lord, which is very, 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 very important, the approach, once again, well, I'm sure by now maybe you've worked out that Jafta J is one of my favorite justices because of his lucidity. Once again, he comes to the rescue at paragraph 105 of that judgment, because he actually makes it clear that some of this debate might actually just be a waste of time. And look at and that's why I was saying the word suspended. Let's keep it on the mind. He approaches the matter on the basis that this whole thing about interdict, pending review, and what have you, is not the only what do you call it route in which the matter may be resolved. The matter may be resolved by simply applying section 172 of the Constitution. Now that's a crucial addition of this case, which many people have missed. He says at 105, to determine whether there are probable prospects against the impugned order, it is necessary to take a step back and trace the genesis of the power to control the exercise of public power by judicial review. The review power comes from the Constitution itself. If I may pause there, that's just to make another point, that, by the way, even illegality and rationality, apart from being a ground of review, is a constitutional imperative, because the rule of law in section 1C of the Constitution is put as a constitutional imperative. So a breach of the rule of law, apart from being a ground of review, is itself a source of unconstitutionality. But that's just an aside. Chapter J then says, the exercise of public power, regardless of whether it flows from the Constitution or legislation, is subject to judicial scrutiny. And this addresses the so-called separation of powers thing. This is what the Constitution proclaims. It is the judiciary which is charged with the function of determining whether other organs of state have complied with the Constitution and the relevant laws in exercising public power given to them. And if the exercise of power is inconsistent with the Constitution, which is what we're saying here, the court before which the challenge is competently brought is obliged to declare such exercise to be invalid. Now, let's pause right there and then go to paragraph 113. He says, therefore, even if it could be said that there were prospects against the grant of the interdict, in other words, where the interdict was not, the applicants for leave would still be faced with the question whether there was a prospect against the suspension. That word is crucial in the context of what I'm saying. Against the suspension. Requirements for suspension differ from those needed for an interim interdict. The outer standard does not apply to suspension. I mean, it can never be clearer than that. The learned judge says the outer standard does not apply to suspension. In other words, if you look at this matter from the point of view of section 172, outer does not apply. I mean, anyway, he then says, yeah, the power to suspend the operation of the public protector's remedial action is sourced from section 172(1)(b) of the Constitution. If in a matter like the present, it is considered just and equitable to suspend a remedial action pending a determination of the review in which the validity of the remedial action is impugned, a court may grant the suspension. Guidance for issuing the suspension derives from considerations of justice and equity, not from outer, not from setlogelo, not from any of those things. Now, then he says at 116, which now brings us back home to this case. As the first judgment observed, the enforcement of the remedial action before the review is determined would be prejudicial to the applicant for review, to the public protector in our case. It would mean that he or she has to be punished in terms of the remedial action which he had successfully demonstrated was likely to be set aside as not meeting the requirements of the Constitution and the relevant legislation. So that's where the intersection between what I'll call the JAFTA test of suspension introduced in this case and the ordinary outer test is. In other words, what he's saying is that he uses the same word, likely to be set aside. Remember earlier we said likely to succeed. Now he's saying even in his test of section 172(1)b, you cannot punish someone when they are likely, when the the action is likely to be set aside as not meeting the requirements of the Constitution. In other words, on the basis of unconstitutionality, not on the basis of review as such. This would be the record, he says, position where the record shows no potentiality of prejudice to the public protector or to the speaker, should the enforcement of the remedial action be put on hold until the finalization of the review application. Its immediate execution would serve no purpose other than short-term expediency. And that's the point, the other point that is so miserably misunderstood when we talk about the issue of whether there is likely to be a removal anyway in the end. We're not saying, well, that point is misunderstood because Mr. Breitenbach said, well, then, and I think the question was, well, then where's the irreparable harm? But that's not the issue is this. And it's an intersection between constitutionality and using powers for a purpose other than the ones that they are intended, as in the case of the Zuma versus National Public Prosecutor, which we cited, I think, in last week's note. That principle is very simple. If you have the power to remove, that's what Section 194 is, heading, removal of the public protector or of whatever, of an official. Now, if you have a set of facts as we have here, where everybody agrees that it is unlikely that a removal, in fact, is going to eventuate for whatever purpose, good or bad or not good, then what we're saying is that that is something that the court must weigh as to the motive for this, which is what Chapter J is saying. Is the court just going to be used for expediency, vengeance, short-term, fulfilling the basic animal instincts in us to just punish those that we may not like? Or is the court going to be used rather to be looking at the prospects? In other words, a different species of what's likely to happen, of picking. So you pick now into whether, in actual fact, the purpose of the Section 194 is going to be achieved. It's the same thing as saying, a policeman might arrest you knowing very well that you are innocent, and even arrest you on a Friday. Make sure that by Monday, by the time it's found that no, you are the wrong person, you have already spent 3 nights in. It used to happen a lot. So they are using the power to arrest, not for the purposes of securing a conviction, which is what that power is supposed to be for, but for another purpose, which is to fix you and show you who's the boss or whatever the thing is. And that's what the case in Zuma versus National Director said, that you may not use the power for a purpose other than the one that it was intended to. And even as long ago, your lordship will know, as I think it was 1967, in the case of Dempsey, and that's the example we give, where the power was used to detain somebody under the so-called Suppression of Communism Act. But the arresting officer knew that this is not what the power, or rather the statute empowered. And therefore the court said, no, you must kick it out, because that is not the purpose. So that example of the numbers, whether or not there's going to be an actual removal, is important for that. For what Chapter J says, that, I'm sorry, if I can just finish the sentence. For what Chapter J said, I'm sorry,
for clarity, the issue of the numbers was raised by the applicant herself.
Correct.
She raises it and says, I don't foresee any risk of me being impeached simply on the numbers. And that the respondent says, or opposing it, speaks directly to the question of irreparable harm. How can there be irreparable harm if the applicant herself says, I don't believe that I will be impeached simply on the numbers?
All right. Okay, let's go back one step. You remember paragraph 67?
Yes.
Yes. What did they say about Mr. Godin? They did not say Mr. Godin is going to be fired by the president, right? All they said is that the irreparable harm was lied in the fact that he's going to be disciplined. The mere process, right? That's what the court said. The court said that advisedly, because it matters not whether in the end the president was going to put Mr. Godin to the firing squad or not. The issue was simply that the process, the mere process of facing the committee, the mere process of being disciplined, irrespective of the outcome, constituted irreparable harm. That is the simple notion that was not being understood in the alleged criticism of the fact that the the intended outcome might not eventuate. It's actually a simple issue of saying the harm is, because it's interim harm. That interim harm has, quite frankly, nothing to do with the eventual outcome. But the issue, the context in which it has been raised here is a different context, which is to say, if you even know in your own heart of hearts, as my rogue policeman, if you know in your heart of hearts that this is not going to come out as the intended purpose of the statute, but you nevertheless pursue it for what Chapter J calls short-term expediency. That's why he says,
Mr. Mpofu, just to assist us there, where did the respondents say that they believe this is short-term expediency, or that they don't anticipate what the outcome would be? All they say is that they can't anticipate what the panel would, or what the National Assembly. The DA has laid the charges on the basis that those charges will be proved. But they say we can't foresee what the political process will eventuate. But I just want to leave you with that thought, but in a broader context, that the decision in the matter of EFF versus Gordon, the factual context, as you correctly pointed out, context is important, is different. In this matter, in the Gordon matter, there was already an investigation. there were remedial steps recommended, or in this matter, there's no investigation yet, and no finding has been made. Is that not? Hold on, please, because when we evaluate all of this and we do the comparison between the two cases, we have to look at and see whether the contentions which you raise about the applicability around those issues of potential harm and all of that are comparable to what is being faced by the applicant, where she's not faced, there's no investigation yet, there's no findings yet.
Yes, that's the whole point of interim relief, is to prevent things from happening. So the point, my lord, I understand the point. Yes. All I'm saying is this: your lordship, you'll never find cases where the effects are the same. I mean, if we are going to look for that, then we must just forget about stare decisis.
Okay.
So the issue here is not that Mr. Kodan, Ms. Mkhwebane is going to face the president and all those things. No, obviously not. The point is the principle. The principle in this case by the Constitutional Court, which is binding on your lordships and your ladyship. The principle is that if you have potential harm associated with facing a committee, not what may or may not happen, and associated with being disciplined. Is that going to happen? Yes or no? Yes, it's going to happen. She's going to be disciplined. She's going to be facing a committee. And as I said, the other additional thing was the spy allegations associated with this. Are they there? Yes or no? Yes, they are. So
hold on. Let's get clarity. Hold on. There's not a single spy allegation in the charges before the applicant.
Okay. The spy allegation, the relevance of the spy allegations do not have, again, you will never find cases that are the same. The relevance of the spy allegations in this case is simply that it's part of, it's a reputational harm. Let me put it like that. I think that's the simplest shorthand I can think of. Is that in this case also reputational harm is implicated. Now, it's a basket of harm. It's not one of those things, and that's why I said, I mean, for example, Mr. Kodan was going to face criminal proceedings. This is not going to happen. You'll never find a case where the facts are exactly the same. What the court was saying is that if you wait, you see.
Mr. Mpofu, I fully agree with you on what the basket of harm that you point out in respect of the applicant. But that's part of a weighing exercise. Yes. And one is to look at the harm that befits, that also has to be considered in respect of the National Assembly, because it's the National Assembly who has an interest in these proceedings, not the DA or the Speaker. The DA or the Speaker, the DA is the mere mechanism to start the process. The Speaker facilitates the process. And it's the National Assembly who has to carry out constitutional functions of holding the applicant accountable. It does that in terms of the Constitution, and it also does that in terms of the public interest. Now, you've not weighed those two harms. Unless you can assist us with that now. Thank you.
No, thank you. Yeah, you've come exactly where I was going, my lord. Two answers to that. One is that, you see, I'm holding four things here, four objects. And then I take away one or two of them. If on the weighing scale, this side of the scale, there is nothing, it doesn't matter if I have 2 or 3 or 8 subjects this side. They will always weigh higher than nothing. All right. So that's the point. That's why I keep on when I read this, I read it by starting at paragraph 66. I say there is no irreparable harm that the public protector would suffer. That's what the court said. So unless if somebody tells us what the irreparable harm that the National Assembly, as you correctly put it, will suffer, since there is no such irreparable harm that the National Assembly will suffer by the suspension of this process until the courts have declared whether or not the rules are constitutional, then it's a wasteful exercise to say on the other side, if I had 8, take out 3 or 2 or 5 oranges, it's still going to weigh higher than nothing. Okay, because the harm, the weighing of the harm, unless if it is weighed, the balancing exercise that your lordship talks about only works when there's something to be weighed against, not when there's nothing, like it was said here. That's the first answer. The second answer is that, my lord, your lordship quite correctly says that the speaker. And maybe we're unfair on the speaker now and again. This is the point we're making about the point your lordship is making. 100% correct. Actually, the speaker is a messenger. Let's call it that, right? Now, this is the constitutional thing. It's not a frivolous statement, and we put that in our note now. And that is why we said. And your lordship unfortunately stopped me when I was making this point at the beginning, rather in chief last week, when I was saying the numbers are important. Look at and that's what I call the atmospheric issues. Look at it like this, my lord, coldly. What do we have here, really? We have 14 political parties in parliament, right? Of those 14 political parties, we have one that is opposing the suspension of the rules until, and that one is the DA. It's understandable because they are the complainant. All the other 13 political parties, at best for us, are either supporting the notion that this court should suspend the implementation of the rules until their constitutionality has been determined. And those parties that have come out clear in the open are the ATM, the UDM, and the PAC that came here. 3. Of the other parties, not least of which is the majority party, because this is a democracy, so numbers are important. The lordship is quite correct. The speaker reports to a constituency. So that's the importance of the majority party. Of the remaining parties, not least of which is the majority party, they've either said, we are going to abide and await the outcome of the court, but they have not said, no, this must happen tomorrow, otherwise the world is going to come to an end, or we will be, the National Assembly will be harmed, as it is postulated now. So the majority of the members of the National Assembly do not perceive harm, so we can't perceive it for them. And the speaker, with the greatest respect, is bound by to listen or to apply the principle of majoritarianism, because this is a parliamentary democracy after all. And that, for that, your lordship doesn't have to go any further than section 57, 1B of the Constitution, which is at the heart of what is happening here. Remember, my lord, that the power of the National Assembly, as you correctly put it, not the Speaker, not the DA, the power of the National Assembly to make rules derives from section 57 of the Constitution. That's right. My learned friends on the other side have accepted that somewhere in their papers. Now, let's then look at what it says, my lord, about how the speaker should, how the National Assembly should do that. It says the National Assembly may make rules and orders concerning its business, which is what they are doing here. But here's the important part. With due regard to representative and participatory democracy, accountability, transparency, and public involvement. That's the point we make in today's note. You'll find that, my lord, at page 9 of today's note, paragraph 31. I'll just read it out. We say, incidentally, the analysis and breakdown of the numbers of cooperating or participating parties, that means political parties, I should have just made it clear because that can be confusing, of participating political parties, the lordship there.
Give me the number, please, Mr.
I'm sorry, my lord. It's page 9, paragraph 31.
Ah, thank you. Yes, thank you.
You're there. Thank you, my lord. We say that the analysis and breakdown of the numbers of cooperating or participating, and I say just put the political parties, is not a frivolous exercise. It points directly to the constitutionality of the speaker's conduct. If regard is had to the empowering section 57(1)(b) of the Constitution, which expressly provides that the National Assembly may make rules and orders concerning its business with due regard to representative and participatory democracy, underlying democracy, accountability, and public involvement. Then we say, in the National Assembly, participatory democracy, accountability, and public involvement are achieved via the medium of political parties who speak for the majority of the citizens. The Speaker is not constitutionally entitled to move on, irrespective of the misgivings of the vast majority of the members of the National Assembly, and by extension, South African citizens, and at the behest of a single political party, which is the complainant and therefore plainly biased. Now, that's why your lordship is 100% correct that what we are looking at here is the National Assembly. So the Speaker is, in terms of section 57(1)(b), cannot just wake up and say, no, I'm doing this. I don't care what the members say. Remember, the Speaker herself is appointed by a majority vote of the members and can be removed by the same majority vote. I'm not suggesting anything like that. I'm just making a point. So, section 1 of our Constitution, these things that are said here do not come. Democracy, accountability, transparency, and what you go back to section 1 of the Constitution, you'll find the exact words are there, where it says, section 1C, this country is founded on the following values, among others, national common voter, regular elections, and a multi-party system of democratic government to ensure accountability, responsiveness, and openness. So that's section 1D of the Constitution. So it's a full cycle.
Yeah. Mr. Pope, just for me to understand this proposition you make,
yeah,
is that we would then have to make a finding that because other political parties have not entered the fray in this matter and have left it entirely in the hands of the court, we must interpret that as being support for the position of the applicant.
No. That's not what I'm saying. I was careful with what I'm saying. I told you which parties support. The ATM, yes, the PAC, and the yes, UDM. Those three support. Now, yeah. Okay. Then I said,
hold on, just on that. We've not heard from the UDM in this application, neither from the PAC in this application.
Well, you have Mr. There's an affidavit which was submitted, and Mr. Sikakane told the court on day one that he's also acting for the PAC.
No, he said he was going to address us with regard to certain issues with regard to the PAC, but never got down to doing it. But even if we were to accept that the PAC is supports.
Well, if you accept that affidavit, yeah.
How are we supposed to? We haven't seen the affidavit. Have any of you seen the affidavit by the PAC? No. Mr. Judge, we haven't seen an affidavit from the PAC.
I'll ask maybe Mr. Mutsepe can tell us if it was submitted. Okay. It was certainly served on us. Maybe it was not delivered to the court. Yeah.
And we've not seen an affidavit by the UDM in support of the applicant's position.
Yeah.
Well, okay. All right. Again, I don't want. Okay. Let's forget the PAC, forget the UDM. Let's say there's the ATM that's before you.
Yes.
We know. I mean, unless the affidavit is there, and it may or may not come. So,
yes. Okay.
Yeah. So, but that again, I don't want to be bogged down as to whether it's the PAC or the UDM or the ABC. The issue is that there are parties. There are political. I'm saying that there are political parties on the version of the speaker. And this is a more generous interpretation. That's where I was going. The speaker says, for example, that 6 parties submitted the the nominations for the independent panel. So I'm prepared to accept, for the purposes of this argument, that those 6 parties, which all are part of a minority, and that's why we said that at best that would come to about 30% if you add the DA as one of those 6 parties. But it still means that the majority of the parties have either supported this application in an affidavit sworn before God, or they have they are awaiting the outcome of the court. But here's what's important, my lord, and your lordship really has to take this into account, because it's one thing to, it's one thing to hear from the public protector about the about the undesirability of going ahead with this, irrespective of the fact that the constitutionality has now been exposed to be lacking. Let's hear what the ATM actually says about it. Go to page 636.
On what volume, Mr. Mpofu?
Oh, I'm so sorry. I'm also one of those low volume people. I've got it's volume 7, I think. What 636. I'm sorry, my lord.
Yes. Okay. Volume 7. Volume okay. 7 of 9.
Okay, that's a good guess. Okay. 636. You know, because it helps to hear from maybe some of the elected representatives. I'm sorry, my lord. It's
no.
I said
636.
636. Is this the right? I'm sorry. ATM affidavit. I think it starts at 623. I'm sorry, my lord. Looks like my note is not ATM. Sorry, my lord, just 1 second.
Okay.
Okay, I'll come to that, my lord. Let me paraphrase it while my learned engineers are finding the passage. What the ATM says in essence, my lord, is that, just you remember, my lord, one of the points is that point about prior notice. The Lordship will remember the point about the failure to give notice to the public protector regarding the so-called in-order decision. Now, the ATM says the following. Remember, these political parties voted for the rules in December. That was before, obviously, before they received our founding papers. So firstly, the ATM said to the speaker, please suspend this entire thing for a few months because we've just received these papers. We would, and this is a serious matter. The speaker said, no, I'm not going to do that. I'm only going to stop it. They asked for 2 months. She said, no, I'll do it for 6 days, which the ATM says was meaningless. Then, so the ATM says, which is very important, that it's, okay, I found it, my lord.
Yes.
It's,
what page?
Let's go to 783, my lord.
783.
Volume 9. The affidavit starts at 772.
Volume 8, 783.
783, my lord. Yeah.
Volume 8.
Yes.
Okay. You got it? Right? You got it? Yeah. Thank you.
Yes. Let's listen to what the ATM says. These are now, as I said, the members speaking for themselves.
Yes.
Says, we are also in full agreement, paragraph 29, my lord, sorry, in full agreement that the current rules properly interpreted could never have anticipated that the public protector was not entitled to prior notification about the content of the complaint and the decision to approve it. That is in other words, what the ATM is saying is that we voted for the rules to be adopted, but we could not have anticipated that the conduct of the speaker is going to be such that the public protector will just read about this thing in the newspaper, as we explained last week. And they say, that she learned about these issues for the first time in the media is clearly unlawful. The refusal by the speaker to furnish the public protector with reasons, this is the second issue, for the speaker's approval decision is just further proof of an unlawful process thus far, right? Then they say, finally, it could never have been in the contemplation of the political parties, including the ATM. In fact, so now they're talking for everyone, that the rules would operate retrospectively. I can safely confirm that this was certainly not the intention of the ATM. The retrospective implementation of the rules by the speaker constitutes conduct inconsistent with the Constitution and is accordingly invalid. And then they go on and on. Basically, they even at 786 is the point that I just made at paragraph 42, my lord, where Mr. Zungula, I think it's the president of this party, says, I requested an extension. The background is that they received our papers and so on, and so they wanted time to apply their minds. I requested an extension of 2 months so that we would make meaningful contribution in the nomination of the independent panel. However, the extension was granted, was for 6 days. That was simply not adequate given the weighty issues involved in the removal of the public protector. If anything, this is the clearest indication that the speaker wants to process the process done as swiftly as possible, regardless of the negative precedent that will be set. This is plainly irresponsible. Then it says the ATM has also publicly and consistently expressed its concern about the undue haste of the Speaker to carry out the removal in spite of the pending litigation from which all parties and so on. Now, why am I taking your lordship to this? For two reasons. One is that it doesn't come from us, because we are obviously a directly interested party. So if the harm and the advisability of awaiting the outcome of the court is even confirmed by members of the National Assembly themselves, without asking your lordship to speculate as to why the others are abiding. But common sense would dictate that if any of those parties felt strongly enough that the rules should be implemented irrespective of the constitutionality check, so to speak, that is forthcoming in Part B, then they would have said so. I'm not saying your lordship must therefore read that they support or whatnot. I'm saying that the mere fact of their silence, of that silent majority, speaks just on the basis of common sense. At least says that none of those parties feels that these rules must be just bulldozed, irrespective of the fact that they are. Remember, by the way, these are legislators. These are not people, in the street. They know how this works, or as they say in the streets, how it rolls. When they pass,
yeah, make that point, because you recall this referral to the ATM's affidavit was in response to the court saying, must we therefore assume that those parties who seek to abide the decision of this court are in fact in support of the applicant? You've then taken us to the ATM. In the one paragraph, the ATM seems to speak on behalf of other political parties. It's got no supporting affidavit. It confirms that this was never in the contemplation of the political parties. It's not supported at all, so that's entirely speculation.
Okay.
And then the other paragraph that you've referred to us is that all the ATM does is that they want an extension for 2 months in order for them to make a meaningful contribution on the panel. Here they don't say, here they don't say, we asked that this matter not be proceeded with because of the review or these proceedings. They just wanted 2 months in order to make a nomination to the panel.
No, my lord, honestly,
that's their own words.
That's just, it's just running with one word. This affidavit says,
it's David.
I'll find you the passage you are looking for.
I found it, paragraph 42.
No, there are many of them. Yeah, there are many paragraphs where they say that the reason they support Part A. I mean, I don't know if anyone has any doubt as to whether the ATM supports Part A, but if there is such doubt, then Part A says that the matter must be suspended until Part B, as we started in the morning. I mean, when we started. But
Mr. Mpofu, I know what the position is of the ATM. Mr. Sikakane argued that. But you've pointed us. Hold on. You've pointed out in response to the question as to those who abide, which you now equate to a silent majority. Abiding a decision of the court means that the party simply takes no position and will abide the decision of the court. The majority party has not filed a supporting affidavit to your client. The majority party has not filed an affidavit in which they are supporting the interim relief.
Yeah, nobody is claiming that.
And this court can't make that leap on these papers. They therefore necessarily support the interim relief.
Okay.
Because you've
Okay.
repeatedly, hold on.
Just flip the logic.
Mr. Pofu, you said that the speaker has to, otherwise the speaker would be acting contrary to the interests or the views of the political parties. You've taken us to participatory democracy, and you've taken us to multi-party constitutional democracy. The majority party has not told this court what its views are.
Yes.
Why do we have to speculate what their views are?
Okay.
It would not be appropriate. It would certainly not be appropriate for this court in an attempt to speculate. That would be going beyond the papers before us.
Okay, my lord. Let me. I'll find a shortcut. What you do know for sure, right, is that 6 parties are participating in one way or another, right? We only have 2 letters, but I'm happy to say it's 6. The 6 that the speaker claims. That you know as a fact, right? Now, the question is that I'm putting to your lordship, bearing in mind, as the Constitution enjoins us to do, the requirements that the National Assembly must pass and implement those rules with due regard to democracy and participatory democracy and majoritarianism and so on, there is a stance that is only supported by 6 of the 14 parties, who make up about 30% of the National Assembly. Is that not a factor in the view of Section 57(1)(b) that the court can take into account? That only a minority of about 30% of the members to whom the speaker reports in terms of Section 57(1)(b), well, let's be generous and say they support. We know that they have not even supported, because it's only the DA that has filed, equally as your lordship's logic about affidavits. The others have not, as I said, felt strongly enough to even put affidavits. But we just through their action, because conduct in law also says something. So I'm saying for those ones, because they sent those letters of nomination, their conduct would generously assume that they support. Similarly, the conduct, all I'm saying is that the conduct of the other parties, and I'm saying this again very carefully for a deliberate reason to avoid this kind of debate. The conduct of the other parties by not associating themselves with the speaker's position and the DA's position is something that is that must be of relevance to anyone who's interested in majoritarianism and participatory democracy. Because the speaker, as you correctly pointed out, is not just a loose cannon. She has a base whose views are important. So if it's up to her, if she doesn't take into account the fact that only 30% or so of her employers, so to speak, support this at best, or 20% if you just look at the DA alone. But I'm prepared again to work it on the generous basis that there's another 10% of those other 5 parties. I mean, there are no other 5 parties, quite frankly, that make up 10%. So it's actually over generous, but there you are. Now, if that factor in a person whose very being is based on majoritarianism and the feelings of the population and the feelings of the populace, so as represented by those 400 members, if that's relevant, well, then I move on to my next point. But yes, the fact remains that at best only 30% of the people, at worst one party, which is also the complainant, is the one that that supports this. So that is why the court has to be extremely careful, going back to where we really were, that as Jafta J said, the only thing that will be achieved, then we must assume that the DA has an axe to grind, feels strongly about this, and as they've shown in the past 4 or 5 years. If that's the only party that is that feels that we should not wait for the wheels of justice to determine the constitutionality and otherwise, and your lordship tells me that the ATM says that they want to wait for the the panel, when the ATM has told you under oath that the rules, when they passed the rules, they did not intend for them to be applied retrospectively, which is what has happened in concrete life. So they did not know that obviously they could not have known that a motion that will come will only refer to things that happened before the passing of the motion. And
so,
that alone, that's an issue to raise pertinently.
Mr. Pofu, let's just pause there. If the ATM was of the view that these rules are not retrospective, why did they ask for an extension in order to make nominations to a panel? Why didn't they say to the speaker, hold on, why didn't they say to the speaker, why are you going ahead with the panel process when we did not think that this process or that these charges operate retrospectively? Where in their letter to the speaker do they say that? They say, give us more time to consider. And that's exactly what you've pointed out. In paragraph 42 of the ATM's affidavit, that's what they say. They say to the speaker, give us more, we don't want to nominate to the panel because this process is not as we intended.
No, my lord, honestly, the ATM says that the rule, firstly, they say they want the extension so that they can apply themselves to the papers, right? So that's common cause.
No. Let's read this. You pointed out paragraph 42.
I'm not remind you what the whole affidavit, not one paragraph.
No. You pointed out the paragraph, not me. In the paragraph, they say they need 2 months so that they could make a meaningful contribution in the nomination of the independent panel. That's what they say in their papers. That's what you pointed out. And I accept the position of the ATM that they support the speaker with regard to the relief. But when you refer to the affidavit, you must look at their own words. That's the only point.
Okay, I promise you, I have no intention of reading the full affidavit. But if we want to, I will do my best to show you that picking one word in one affidavit is.
Mr. Kofi, I accept.
Okay, here's the letter. Look, go to page 792.
792. You got it? Yes.
Yeah, 792 and 794. Look at this. They make the point that we've already made, and look at just paragraph 2.
Say,
yeah. Why they want the thing. The ATM is. I'm sorry, my lord. Just 1 second.
We got it? You got it? Yes, we with you?
Sorry, my lord. Yes, I was just giving instructions here. Says, number 2, we have just been served with the papers from the public protector's attorneys interdicting the whole process. ATM is starting these papers and will respond to them in due course, okay, which they did, we now know. The 2 months proposed extension should provide sufficient time for all the legalities to be clarified, right? In other words, all the legalities, including those issues raised in the founding affidavit. Then go to 794.
Yes.
Yeah. Okay. Now, it can be clearer than that one. This is the ATM releasing a statement. The ATM appeals to the Speaker of the National Assembly, Honorable Thandi Modise, to err on the side of caution and declare a moratorium on the process for the removal of the public protector from the office until a court of law has pronounced on the legality of the rules recently passed in Parliament. And then they won't go on. I'm not going to read the whole thing again. Yeah. So anybody, and the ATM, by the way, is here supporting Part A, the whole of Part A. They didn't say they only support it to for the purposes of a panel. Paragraph 10. And at paragraph 10, they say, I'm sorry. I'm sorry, my lady. I mean, my lord. It's page 774.
Yes.
The purpose of this affidavit is twofold. First, I set up the basis of the ATM's contention that the process for the removal of the public protector ought to be suspended, right, until the substantive challenge against the impugned rules has been finally determined. Second, I set out the reasons why the ATM submits that the proposed implementation of the impugned rules does not pass constitutional muster and should be nullified and set aside. I mean, no. So when we read an affidavit, is not. I mean, we can all pick one sentence or one word, but the ATM makes it clear that A, it wants the thing to be suspended, and B, that it's unconstitutional and invalid. Okay, now if we and just to be clear again, I'm not saying I'm simply saying that that view is expressed by part of the constituency, which has been ignored by the speaker. Firstly, in respect of the time they needed just to make up their mind. As it happened, they did do an affidavit at a later stage, even though they were not given the time that they needed. But secondly, they make it very clear that why the rules are unconstitutional. It can never be clearer than that.
Yes.
So they can't possibly be saying the rules are unconstitutional and invalid, but we also like them. Okay, so so that's the what if you like then the EFF versus Godin test. As I'm saying, it has been satisfied both in its outer incarnation of the irreparable harm, which we have discussed earlier, but I'm saying on top of it, it has also been satisfied in its chapter J incarnation as a suspension, which you see even the ATM is couching it in the words of a suspension. And so did we, by the way. If your lordship goes to page 500, what volume is that? Volume 6. There, the lordship will see that as long ago as January.
Volume 6. What page, Mr. Impofu?
Page 500, my lord. Volume 5. Volume 5. Yes, I'm sorry.
No? Okay. Here you are. Yes, we're with you. Page 500. Thank you.
Yes, I'm simply demonstrating here, just for a few minutes, that the, let's call it the chapter J approach is competent in these proceedings as well, because the relief or the, I think your lordship himself actually last week put it to one of my colleagues that in effect what is needed, what is being asked for here is a suspension of the rules. But anyway, in case there's any doubt about that point, at paragraph 17 on page 500, we say that this is the very first letter 3 days after the press release, shocking press release about the process. So, furthermore, our client hereby requests an undertaking from the Speaker that the grossly unfair process which has been unlawfully initiated in terms of the impugned rules be temporarily suspended until all the above issues have been adequately dealt with, either amicably between the parties or failing which, if needs be, by a court of law. At 503, just in case there's any doubt as to whether the Speaker understood that to mean a suspension. So just 3 pages later, this is what the Speaker says in her reply to that letter. I call this the confession letter. This is where she literally confesses that she broke the law, but I will come to that now. It's on volume 6 now.
Yes.
While we're on that letter, I'll use it so that we don't come back to it. I'll use it for the other purpose. But for now, I'm using it for the last paragraph, my lord, where she says, the Speaker says, Parliament's process and the rules adhere to the rules of natural justice, including the Audi alteram partem rule, and are informed by the relevant constitutional principles of fairness, transparency, and accountability. So at least we all agree on the standard. Whether it's applied or not is another question. And then she says, there is accordingly at present no reason to suspend the implementation of the new rules. So she knew exactly what it is that we're asking for. But in case there's any further doubt, go to page 76 of the papers. 76. That's volume 1. I think I can work that one out.
Yes, thank you.
Yes, if you go to paragraph 169, and again, we apologize for the bad numbering of that. Is the vagaries of urgent applications. But, paragraph 169 says, by her refusal to suspend the implementation of the removal process, the Speaker has caused me reasonably to apprehend that unless the relief sought is granted, it is a clear intention to proceed, blah, 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 blah. And if you go to the next page, 77, at paragraph 171, if the aforementioned rules are not temporarily suspended, I may be removed from office and so on and so on. So from those 6 or 7 or whatever number of references, it can leave no doubt in anybody's mind that this matter can be approached on the chapter J approach, which simply says that you look at the likelihood of success in relation to the two harms, and we've already gone through the fact that it's the two harms is 0 against the harms, the Godin-like harms. And my lord, I must pause here to say this. We have shown that it can never be even on the chapter J standard of equity and justice. It can never be that the justice in this country has one standard for a Mr. Godin and another standard for the public protector when there are comparable circumstances, not the same. We know they're not the same. When there are comparable circumstances. It can never be. You can't say to the same public protector one day, and when I say you, I'm sorry, I mean the judiciary as a total. Our judiciary cannot say to the public protector one day that look, the mere fact that somebody has these potential calamities and they have gone to court is sufficient for you to halt your action, however important your remedial action is. We all know the public wants justice and so on and so on. But the court says, you must not do that because there's a case which is likely to succeed, and therefore you must be stopped. And then she says, oh great, now I've learned the law as espoused by the no less than the Constitutional Court. And then the next day she goes to Cape Town. And then there's a different standard. She's told, no. It doesn't matter now, today. It mattered last week. It doesn't matter that you are going to be disciplined. It doesn't matter that you are going to face personal, something detrimental to your personal circumstances. It doesn't matter that you're going to meet something detrimental to your career. No. That's all unimportant this week. Last week it was important because it was Mr. Godin. But now, because why? I mean, and in relation to I've said it, to the spy allegations type of harm, and I accept your lordship's qualification that doesn't form part of the charges per se, because as I say, no two cases are the same. But we've given your lordship two other cases where Mr. Hanekom was also given interim relief on the basis of spy allegations, because the court said these kinds of allegations are so detrimental to your personal interest that you should be given interim relief. We've also given your lordship the case of Delil, which happened there. Mr. Breitenbach will remember, he was my opponent in that matter. And Justice Samela and Mr. Gamble, where we got interim relief for Mr. Delil on the basis that, in fact, in that case, Justice Samela will remember, Justice Samela and Justice Gamble actually found that the prima facie right was very weak. That's what they said. But they granted the interim interdict on the outer principle, irrespective of that, because they said this will have a detrimental effect on the citizens of Cape Town. Now, Cape Town is very important, but it can be more important than the whole country. So on the poor citizens of the country who are served by the Office of the Public Protector, and that goes to the question of the destabilization of the office, which we raised earlier. Surely the poor citizens of the country are not less important than the citizens of Cape Town. And there is no reason that anybody can tell me what the difference is between Mr. Hanekom, Mr. Godin, and Mr. Lil and Mr. Mkwaban. So we can't have one law for, we've gone past that stage of having one law for some people and other laws for the other, even those who might be referred to as girls in this country. So that's what he said at paragraph 27. I mean, this court, Gamble J and Samela J then. As far at paragraph 27, and I must apologize, my lord, the Delil case that is in the bundle we put this morning is the wrong one.
Thank you very much for that.
It's part B, yes. This was the part A one. At paragraph 27, I will apologize for that. We'll send the correct one. It said, as far as harm is concerned, we do not perceive irreparable harm to Ms. Delil in her personal capacity. That's what this court, Gamble J and Samela H said. Her loss of income, status, and freedom of association of association with the political party of her choice are all capable of being addressed later in the reviewing court's finding in her favor. And I'll come back to this point, because this is the only alternative remedy Mr. Breitenbach could think of, was that in part B, there will be a recourse. I mean, that's just, I don't even know what to call it. Because you are talking about the harm between now and then, not the harm that might ensue as part B. So quite frankly, there's no harm. I'm sorry, there's no alternative remedy in front of you. And I'm addressing that so that I don't have to go to that element. Mr. Badlander, in his defense, did not even attempt to suggest that there's an alternative remedy. He just said, we did not show that there's no alternative remedy, I mean, which is just like saying nothing, because he must show us what is the alternative remedy that is postulated. Mr. Breitenbach, for his part, tried. He says, no, the alternative remedy is part B. I mean, anyway, so...
Sorry, Mr. Poof, that's not entirely correct.
Yes, I'm sure your Lordship will educate me how incorrect it is.
They say the alternative remedy is A, for her to participate in these proceedings. That's one of the alternative remedies. And then part B is one of the further alternative remedies.
I missed that first part.
No,
well, that first part, it's wrong.
Hold on.
Okay.
So she says that you can participate in these proceedings. If at the end of these proceedings, you believe that they've acted unlawfully,
you can review.
You're also entitled to review. That's the second alternative remedy. And the third alternative remedy is part B. So there's not just the one. There's the three that you have to assist us with.
Yes, again, times 0 is 0. Yeah. So the first one, that's the point I'm making. You can't say that to somebody. That's exactly what was said in EFF versus Godin. That no, there's no alternative remedy, because the parties, they were saying, no, you'll go and be disciplined by the president, so to speak, and then you can get your relief in part B. That is not alternative remedy, because alternative remedy is not, this is the point I was making. You must know that interim relief is for the period between now and the part B, irrespective of the outcome. So you can't say your relief, I mean, it's just a laughable concept. Your relief is actually the very thing that, the very calamity that is being foreshadowed in part B. How can that be, my lord? Then interim relief would never be granted. Then all this debate about is it likely to succeed and what have you, it's just futile, because it doesn't really matter actually, because you'll get your recourse in part B. I mean, what is that? It's and then I didn't quite catch the second. Oh, the second one is she must participate. Well, again, if you participate in the very thing that is harmful to your interest, namely, for example, in Mr. Godin's case, to go and appear before that committee. If you do exactly that,
let's just go back, Mr. Mpofu, let's just go back to the remedial action that was ordered in that matter. First is that the president have you got the remedial action?
No.
That's based on a finding of the public protector already. That's in paragraph 14, the footnote 7.
I'm done. Thank you.
Footnote 7, okay?
Yes. I'm familiar with that case.
Yes, okay. So the first one, a finding has already been made against Mr. Gordon in the remedial action report. And so the president has to take disciplinary action against him already. There's already an investigation, a finding, remedial action.
I know, my lord. I'm involved in that case in another court. I know exactly.
Yes, and that's fundamentally different to where we are in this matter.
The facts, yes.
You accept that?
Yeah, the facts are different, yes. But as I say, what I'm after is not the facts, it's the principle. The principle is that the mere fact of facing a parliamentary committee is part of the basket of harm. That is undeniable. So
we've debated this piece already. So
yeah,
let's move ahead. I just want to point out to you that
anyway,
the reason why I pointed it out to you is that the facts in that matter differ from the facts in this matter.
I plead guilty.
The sole principle with sole principle and apply to the facts of the particular matters.
Yes. No.
Good. Thank you.
I plead guilty on that one. The facts were different. Yeah.
Good.
Okay. So I'm then saying on paragraph 27, where we were. I was just on the aside dealing with the so-called inadequate, what do you call it, alternative remedies. So apparently we have three. One is that she must participate. The other one is that she must wait for Part B, and I forget the third one. But all of them are just irrelevant. Okay. So this is what the learned judges said in the Delil case. The matters are capable of being addressed later in the reviewing courts if the reviewing court finds in her favor in Part B. We are, however, genuinely concerned about the harm which her loss of offices for the people she's supposed to serve as the executive mayor of Cape Town. In our view, this factor needs warrants serious consideration in relation to the balance of convenience. The importance of that, again, the facts were different. But the importance of that is that the court dealt with two requirements in one paragraph, which was quite deft. It looked at the balance of convenience, but it also looked at the harm which goes beyond the individual person. And in this case, the harm that has been pleaded has been the destabilization factor on the beneficiaries of the services of the public protector, on the office itself, and of course on the employees would depend on her for leadership and progress. I mean, I don't think really seriously anybody can seriously say that the potential suspension of a public protector is just one of those things, or a minister for that matter, or an MEC or whatever, or a speaker of parliament. But hey, if you weigh that, as I say, against nothing, because we still haven't heard what the harm is on the other side, then at least those two requirements, the one that I've addressed of no alternative remedy, and the one of irreparable harm. Remembering all the harms, we've spoken about the potential suspension, we've spoken about the destabilization, we've spoken about the personal effect on her and her family. We've spoken about the impact on the employees and the impact on the public at large. At least those five, I can stop there. Weighed against nothing must count for something. Apart from the disciplinary action itself. And that's the important thing here, my lord. Again, the facts are clearly different, but the fact remains that both Mr. Gordhan and Ms. Mkhwebane, the harm that they were going to face was facing disciplinary proceedings. That much cannot be denied. The one was by the president, yes, of course, and the remedial action had already been given, yes, of course. But the harm that was identified by the court, at least, in the Constitutional Court, paragraph 67, was the harm of. Now, this is so that then deals with what I call the requirements for interdicts. The court may or may not accept the fact that those requirements were refined or redefined or explained further or whatever in the EFF Godan. But we apply the standard as set out in the EFF Godan at paragraph 66 and 67, and as set out by chapter J as an alternative pathway. Yeah, that's the way I was looking for. An alternative pathway to the suspension of the implementation of the rules. On both tests, on both the, let's call it the Khampempe J test at paragraph 66 and 67, and the chapter J test at paragraph 105 onwards. In this particular case, the requirements have been met. Why do we say, and this is, I deliberately, my lord, because last time, because of time, we started with the prima facie right and the prospects of success. So this time I deliberately, so that if I run out of time, at least I know that the court has had the benefit. I deliberately start with the irreparable harm and no alternative remedy, the balance of convenience, which are the standard requirements, whether you are in Sitlukhelo land or in outer land. So now I want to address the real heart of the test, which is, are the grounds that have been advanced by the public protector likely to succeed using the EFF versus Godan test? And I do that with respect by referring the court very briefly to 4 of the grounds, as I've said, of the broad grounds. One is fairness, and I'm not going to repeat what I said in chief. I'm just going to respond to what was said by the respondents. The other one is rationality. The other one is retrospectivity. The other one is separation of powers. And my respectful submission, each one of those is strong enough and likely to succeed in Part B, unless that's. As far as fairness is concerned, it's self-evident, my lord, that, and this is the point that the ATM makes and that we made the other day, that the decision to declare, that decision is made in terms of Rule 129R, 129S, and 129T. Any reading of those rules, any impartial or dispassionate reading of those rules will disclose one thing and one thing only, that the speaker was meant to evaluate the motion both in its procedural aspects and as well as in its substantive aspects. And your lordship, for that proposition, must just go to page 142. I'm sorry. I gave your lordships a few pages that I said cover this matter. So to be true to that, if I may just use that, I said between 575 and 530 is where you will find everything you need. So if we can go to 470, I'm sorry, my lord. 476 in volume 5, 477 actually. The lordship there?
Yes, thank you, I am.
Thank you, my lord. Okay, like even a first-year student will tell you that, my lord, at where it says any member of the assembly may, by way of notice of a substantive motion in terms of Rule 124, initiate proceedings, section, provided that, and then look at A. The motion must be limited to clearly formulated and substantiated charge. So it's not just about form. On the grounds specified in section 194, so it refers you back to section 194, the 3 grounds which we know, which must prima facie show, in operative words, that the holder of a public office committed misconduct, incapacitated or is incapacitated or is incompetent. Anybody who tells you that that is a procedural requirement doesn't know what they're talking about. Because as I say, in the first thing they teach you at first year is that the substantive law is the one that tells you about the elements of the crime, for example, if it's criminal law. And procedural law is the one that tells you about how the court will. So that's clearly substance. And then B and C might be borderline, but go to D. Provided that the motion is consistent with the Constitution, the law, and these rules. Again, anyone who says that's a matter of procedure doesn't know what they're talking about. Because consistency with the Constitution, that whole book, cannot be a procedure. And then it says, if we jump then to T, when the motion, in other words, only once the motion is in order, the speaker must then immediately refer the motion to an independent panel, blah, blah, blah. So once she's happy that the 129R, 1A and D, among other things, have been satisfied, then she can go ahead. And here, let's go to what I call the confession letter, page 502. Volume 6. Given that heavy task, the speaker tells this court openly, unequivocally, that she did not do her job. If it was a criminal matter, this would be what the confession, section 217, I think that's what it's called. 502, are you there, my lord?
Yes, I'm good.
Yeah. She says, just look at the bottom. I therefore confirm that the substantive motion complied with the form requirements in the rules. So she only checked the form, not the substance, as she was enjoined to do by 129R, S, and T. And then, for the avoidance of doubt, go to the next page, 503. She says, no decision has been made, at least by me, I suppose, as the speaker, as to the required prima facie assessment as the independent panel is yet established, after which the panel members must conduct and finalize the preliminary assessment. That's confession number 2. Confession number 1, she says that I've only confined myself to form and not substance. Confession number 2, she says I've not made any decision about the prima facie assessment. My learned friend, Mr. Breitenbach, to his credit, submitted that actually there is what he called, I've got his notes here, a double sifting mechanism. I'll find the exact, but the court can accept that in his notes. That's what he says, and that's what he said. What does that mean? It means a simple thing, my lord. In fact, this point, this letter should be the end of this case, because it means a simple thing that the speaker was supposed to have the first sifting mechanism for prima facie existence of the what you call of the elements of the crime, to stretch a metaphor, and she didn't. I mean, by her own confession, she didn't do that. The mere fact that there is another sifting mechanism in the form of the what you call the panel does not absolve the speaker from performing her own sifting mechanism. Because, my lord, it's like that's why we said in this, she's almost like the prosecutor. Her own decision as to whether there's a prima facie case then goes to the next stage. But it doesn't mean the court might also find that there's no prima facie case and discharge someone under Section 174 or whatever it is. So those are two sifting mechanisms. So both of those sifting mechanisms should attract a hearing. At the very minimum, a notice. If not a notice, then at least a hearing. But she says to you openly, I did not do that. That the rules require me to do. So, I mean, so that means two things which are fatal from a constitutional point of view. One, she failed to give Audi as she was enjoined to do. But secondly, she misconstrued her powers, which is a different ground of unconstitutionality, because she thought she can do what Baxter calls passing the buck. Passing the buck is a form of, it's called abdication and passing the buck. It's called unlawful referral. In other words, where an official says that I'm not going to perform my duties, I will leave it to somebody else, when the law actually says that you must perform it. That alone is a ground for invalidity called passing the buck or unlawful referral. So this is a double. Firstly, she did not. It's as a third one. It means she did not apply her mind to relevant factors, such as whether the motion complies with the Constitution or not. So three damning unconstitutionality grounds confessed at page 502 and 3. No Audi, no misconstrual of the rules, and failure to apply your mind to a relevant factor prescribed by law. So that's just on the fairness. The importance of that, my lord, goes to, I'm jumping to another topic, sorry, very quickly, so that if I forget, I don't. Remember, Mr. Badlander spoke about severability. In other words, whether, even if you find for us, and he said on some of these grounds, can it be that you can just say, okay, well, these parts or this conduct was unlawful. Now here, this is what you call the gateway provision. It's the ticket to the game. You don't get into the stadium unless there has been this sifting mechanism. So it's not so if it is flawed itself, then the entire thing must just go to the dustbin, because if the very first decision ever to be made is, well, according to the speaker, a no decision. I mean, it can never be. Nobody can put it clearer than that. Then, on fairness, we go to very quickly to the question of legal representation. Again, there's no answer to that, my lord. There is simply no answer. Your lordships and your ladyship know that and here's the most interesting thing, my lord. You remember that these rules, we have said that these rules, and well, not only what we have said, it's obvious that these rules are cut and paste from the Section 89 rules. And I think that much has been accepted, except that we were told there's nothing wrong with that. Well, there are two things that are wrong with that. Firstly, the constitutionality of the Section 89 rules itself has never been tested. So to copy the wrong thing might just not take you anywhere. But be that as it may, look at, just for interest's sake, my lord, look at paragraph at page 168. Column 2. And then if your lordship is able to do that, at the same time,
just give us a second.
Okay, my lord. Okay.
And we're according to 8168. There we are. Yes, thank you. We're with you.
Yes, I'm sorry, my lord, to do this. If your lordship can at the same time open 480. Which is, I think it's volume 5.
Yes, we're with you.
Let's head to your lordship. I apologize again.
That's fine.
I just wanted your lordship to just see the mirror image. This is what you call cut and paste gone wrong. And there's no explanation. Look at the bottom of at 168, rule 129M sub 3. Right at the bottom.
Yes.
Yes, it says the committee must afford the president the right to be heard in his or her own legal defense and to be assisted by a legal practitioner or other expert of his or her choice. Full stop. Then, when these rules, which are a cut and paste of these rules, now let's go to 129 at 480. It's rule 129AD3. That one says, word for word until the word choice. The committee must afford the holder of a public office the right to be heard in his or her own defense and to be assisted by a legal practitioner or other expert of his or her choice. That's where it should end. But it doesn't. It then goes on to say, provided that the legal practitioner or other expert may not participate in the committee. That part is not in the rules from which these clauses were stolen or were uplifted. Word for word. And therefore, again, this is plain stuff. There must be, when you are acting in official capacity, you can't just do things because they feel nice. So there must be a justification. That's what Etienne Murenic, professor, said. The Constitution demands a culture of justification. You must justify your actions when you are acting officially. So what is the justification for the adding of those words? Provided that the legal practitioner or other expert may not participate in the committee. That is what is called in elementary constitutional law a limitation of a right, which the word limitation in constitutional law is a synonym to infringement of that right. Because on what basis then is the right to legal representation infringed to the extent that is not even envisaged in the rules from which this was picked up, whose constitutionality is itself in doubt? I mean, it's a no-brainer, this one, that here there's a clear abrogation from the Constitution. And for that, my lord, we can do no better than what Justice Samela, sitting with you there, said in the case of State versus Cornelius. Which is 2008 bracket 1 SACR 96C. You'll find that case, my lord, in the new bundle we served today at page 175. This is what Samela AJ said as he then was. 175.
Thank you.
Yes. Okay, just so that we're clear again, I accept that this was a criminal case and the facts were different and so on. The principle is simply that when there's an adverse, your lordship will know that in labor law, even, for example, some of the standards of your pleading and the charge and what the same language is used simply because of what Chittle called that suspension and dismissal is the employment equivalent of the death sentence, as they say. So I accept those qualifications, but the principle is the principle. And this is what Samela J said at paragraph 13, my lord. Here he was faced with a situation where the magistrate had not sufficiently warned the person of their right to legal representation. And I'm after the principle again. He says, as a result, when an accused person is advised of his or her right to legal representation, the distinction between three forms of the said right should be clearly made in order for the accused to understand them. And this is the important part. It says, indeed, the Constitution does not only confer the right to legal representation, but it also requires in peremptory terms that the accused be informed promptly of the said right. Now here the accused is informed that you may bring a mummified legal representative. And then it says, it must be borne in mind, says Samela H.A. with respect, must be borne in mind that the exercise of the right to legal representation is of critical importance in any trial, as it is the only source through which the other rights can be effectively exercised. And that's the part I commend for this court. But the right to legal representation is not just the right to have somebody wearing a suit next to you. It is the source through which the other rights can be effectively exercised. And the court actually makes the following remark, which is important, another aspect of why that right is important. Because if it's not exercised, then the presiding person is then forced to intervene. And he says, the learned judge says, it also eliminates the need for the presiding officer to assist an accused, which is an onerous task, demanding a delicate and balanced approach test, lest the presiding officer be accused of having descended into the arena of the trial. Now, that proposition is self-evident. If you say your legal representative must not talk, then whoever is presiding is going to be forced to almost be doing an inquisitorial approach to say, no, you can't say that, no, you can't answer it like that, no, the question has already been put, and so on. And then it undermines the effectiveness of the proceedings. I don't think I need to motivate further that that new rule at 480 breaches the Constitution, or at least is likely to succeed. I mean, at this stage, in interim proceedings, I don't even have to go as far as I'm going to say that it breaches the Constitution. I simply have to show that it's likely to succeed in Part B. And these are strong grounds. And then the last one is Nemo Judex. And Nemo Judex, we have spoken about it in the His Lordship and I had a discussion about Nemo Judex before. But I just want to, today I only want to say one thing, which is articulated in today's note, my lord. Firstly, I think we should go to, yes, today's note, we deal with it twice. Firstly, we say we clarify the issue of Nemo Judex, what it means, that whole debate about bias and conflict, which I think has now been settled. At least Ms. Bauer did not embrace the notion that there's a distinction between the two, because the president at paragraphs 29, 26, rather 26, 29, 32, 35, and 38 of his affidavit. I'm now reading from paragraph 9 at page 3 of today's note. In all those paragraphs, it's clear that the president is conceding to what we call reasonable apprehension of bias, or of reasonable apprehension, not actual bias. And then we make the example in case that's still, and then we give from the Oxford Dictionary of Law at paragraph 8, the next paragraph. It explains what the two rules of natural justice, and then it says the first rule in the middle there. There are two principal rules. The first is the rule against bias, i.e. against departure from the standard of even-handed justice required of those who occupy judicial office. Nemo iudex in causa sua, or in propria, no man may be judged in his own cause. This means that any decisions, however fair it may seem, is invalid if made by a person with any financial conflict of interest or other interest in the outcome, or any known bias that might have affected his impartiality. Now that's proof that the two words are synonymous, are used interchangeably. And then it says the second rule is Audi, which we've already said. And then we make an example there, my lord, which I'm sure your lordship, I think from the question I asked last week, looked like you was not aware of. We say that a pertinent example is the fact that in this case, this very case, Judge Desai was supposed to be the presiding judge, and he recused himself on the simple basis that he was one of the applicants for the position of public protector. Now we say that does not mean that he was going to be actually biased or that he had a conflict of interest. It's simply he was responding properly with respect to a reasonable apprehension of bias that any of the litigants might have. And that's why he wrote a letter to all the parties to say, here's the thing, if anybody wants me to recuse myself, I will recuse myself on that score. That's a pertinent and live example of the difference between actual bias and a conflict of the intersection between a perceived conflict and potential bias as opposed to actual bias.
For clarity, how could there possibly be a reasonable apprehension of bias on any of the by any of the parties if Judge Desai had presided in this matter?
No.
What would be the reasonable apprehension of bias?
Yes. Yeah. Okay. Thank you. Let me explain. Firstly, I'm not Judge Desai, so I'm simply saying that what he wrote to us, right? Yes. He said we all understood it in the same spirit. He said, I am, which is what you do if you are sitting in a board, for example. I'm disclosing the fact that I was a candidate. Yes. Should any party, because of that, perceive a reasonable apprehension of bias, then I will move. Now, here's the answer to your question. Obviously, what Judge Desai was alluding to was that, for argument's sake, the public protector could say, I don't want, I'm in a situation where I've got adverse consequences which might befall me. And I don't want that question to be decided by somebody who's conflicted or has a potential conflict, in the sense that they were my competitor for the unsuccessful competitor at that for the job. All I'm saying is that that was commendable and admirable of Judge Desai to raise that point. I'm not saying whether he was right or wrong. I'm saying a judicial officer, proper judicial officer, should behave like that. That they bring it to bear, because and I'll read the quotation now. The courts say that anybody who thinks that they might be predisposed to be to have a, what do you call it? I'm sorry, a biased view on the matter. Anybody who thinks that someone else might reasonably, and that's an objective test. It's not about Judge Desai or the public protector or this one or that one. If there is an objective, and that's what the president was saying. The president is not saying I'm biased. He's saying, because I'm involved in litigation with the public protector adversarial, where she has found made findings against me, a reasonable person might comprehend or apprehend that I will not bring a, what do you call it, a neutral mind into the matter, and therefore I will delegate that purpose, that thing to another person. Let me explain it like this, my lord. In the words of Justice Hlophe, sitting in that court, or in this court, theoretically we're in the court now. And your lordship will find this at page 141 of the bundle, the new bundle of authorities. And this kills two birds with one stone. It deals with any ambiguity about the meaning of bias, but it also deals with the question your lordship asked me last week about if the DA members are disqualified. You remember we relied on paragraph 117 of the EFF case, and my learned
minority judgment.
Yes, that point was made. I'm sorry. The point was made that this point was made in a minority judgment. I mean, as if the principle suddenly transmutes or lessens if it's in a minority judgment. A right principle such as Nemo or UDEX. But so we concede. So we concede that point.
No, it's not as simple. It was a minority judgment which was not affirmed. By the majority judgment. That's the difference.
Yeah.
And that's
that was very bad. Yeah, we accept that. So we're saying, and so we rely on the principle itself, not on Zondo DCJ's articulation of it. Yeah, it was very, very bad. So at paragraph 15 of at 141, now this is how Proper J saw it in a majority judgment, actually in a unanimous judgment. So at least now we are on safe ground. This is what he said at paragraph 15. Mr. Trengove, who was then representing Ms. Delil, argued that Mrs. Delil did not get a fair hearing at all before the ad hoc committee. The ANC members of the ad hoc committees tried to exclude her from its deliberations. Different facts. They came with a prepared motion on the recommendation to be made regarding her conduct and appropriate steps to be taken in relation to thereto. They never attempted seriously to inquire into her conduct. Here's the principle, starts here. They prejudged the case before the hearing. Therefore, there was actual bias on the part of the ANC members of the ad hoc committee. Alternatively, in this respect, there was a reasonable suspicion, which is the same thing in legal terms, of a real likelihood of bias on the part of the ANC members represented on the ad hoc committee. To counter this submission, Mr. Yennes contended that whatever, and the court didn't accept it. But just to save time, let's go to paragraph 17 on the next page, because this is where the crux of the point I was trying to make now about Judge Desai comes. In the middle of the thing, it says, okay, it is not bias per se to hold certain tentative views about the matter. We've said that in our note. But it is human nature to have a certain prima facie view on any subject. A line must be drawn, however, between mere predispositions or attitudes on the one hand and prejudgment of the issues to be decided on the other. And this is what the learned judge president said, although he was not that at that stage. Bias or partiality occurs when the tribunal or committee or judge approaches a case not with its mind open to persuasion, nor conceding that exceptions could be made to its attitudes or opinions, but when it shuts its mind to any submissions made or evidence tendered in support of the case it has to decide. Here's the crux. No one can fairly decide a case before him if he has already prejudged it. Thus, prejudgment of the issues to be decided, which is in a sense prejudice, constitutes bias. The entire proceedings become tainted with bias. The reason is self-evident. Justice must be rooted in confidence, and confidence is destroyed when the right-minded people go away thinking the judge was biased. So if right-minded, that's the objective test. The crux of the Nemo Judex attack to these rules is that, and the Lordship and I had a debate on this a week or so ago, is that the public protector, or anybody for that matter, just like Ms. DeLille, is entitled to not to be judged by those who have already passed judgment on her. And that includes people there are different brands of bias, if you like here. The first brand of bias is the one that the president talks about. The second one is the one of prejudging the issue. Now, here's the thing, my lord. Let's start with the first brand of bias. The president says, rightfully so, and again we commend him just as we commend Judge Desai, says, because of this litigation, this acrimonious litigation or whatever that is happening, someone objective might think that I'm not going to bring a proper mind. I'm sorry. Oh, there you are. To bear on this issue. Similarly, remember that the Speaker of Parliament is in the very same matter that the President says is the source of his conflict. The Speaker is also litigating against the public protector. In the very same matter. I mean, it can never be better than that. And but the President perceives a reason to recuse, but the Speaker doesn't. Same matter.
Isn't right? The grounds, hold on, Mr. Mpofu, isn't the grounds fundamentally different?
Yes, because they are different people.
No, not quite different people. The principle is very different. Findings were made against the president.
Yes.
Yet the Speaker says, I intervene in this process because I need to uphold the role of the Speaker in the National Assembly. And I need to protect the National Assembly. She doesn't do it in her personal capacity. That's different.
Yeah, of course, they're different. The president is the president, the speaker is the speaker. It's not true, by the way, that it's the other way around. If you look at the judgment, the Busasa judgment, you'll find that at 2020 bracket 2, all South African reports 865, yes. 865 GP.
Yes.
This is what the court actually said there. The speaker and the NDPP are the main proponents of the review of the remedial action directed by the public protector in her report. The president supports the review. So what actually happened in reality is that the speaker was the at least the court found that those were the main proponents, and the president was merely supporting them. But this is the important thing. I'm sorry, that was at paragraph 163 of that judgment. Yeah, and this is what the court then said at 206. What makes the public protector's conduct in this regard worse is that despite being requested to give the president an opportunity to respond to the remedial action she had in mind, she refused to do so. The president was not given sight of her remedial action directing the NDPP to investigate money laundering. It is unclear why the public protector failed to comply with one of the most fundamental principles of natural justice by declining the president's request to be permitted to make representations on the remedial action. It would not have unduly slowed down her investigation, which seems to have concluded at relative speed, to be conducted at relative speed. The public protector ought to have understood the importance of not making findings that will have such serious implications without affording a proper hearing to the persons affected. At the very least, she failed to show appreciation of the elementary principles of due legal process. All I'm saying here in respect of that, that is exactly the same thing that the speaker in this case has done. So there's no law for the president and another law for the public protector. If it was unconstitutional for the public protector to not to notify the president of such adverse findings, it's similarly unconstitutional for this speaker not to. Then the third issue on nemo judex.
Sorry, not to notify. Sorry, just make the point.
Okay. No. If you not wanted to ask about this, you can ask me now because this is a separate point.
Yes. Okay. The position of the president and the speaker. Why has the applicant equate that as the same? Because the speaker has explained in her affidavit why she intervened in the process and why she's a party in the process.
Yes, no, that, yeah, your lordship said that before. Let me, the answer to that is found in it doesn't, your lordship said, for example, that last week or the other week, the speaker was performing her duties. The DA was entitled to formulate the charges, which nobody is quibbling about, and so on. But that's not the issue. The issue is, if your lordship goes to page 16 of our today's note, we answer that proposition squarely. At page 16, paragraph 59. And again, it's another unfortunate overlap of the issues, because as far as this particular proposition is concerned, the question of bona fides, the fact that you're just doing your job, is mightily irrelevant to the inquiry, the constitutional inquiry, and that much was made clear by Mohammed CJ in the, you remember the Dalil case that I just referred to. It then went to the SCA, and that in the SCA, this is what Mohammed CJ said about what was being put to me. And you'll find that at paragraph 59 of our note. It says, the inquiry on constitutionality must crucially rest on the Constitution of the Republic of South Africa. It is supreme, and that underlining on it was Mohammed CJ's own underlining. It is supreme, not parliament. It is the ultimate source of all lawful authority in the country. No parliament, however bona fide or eminent its membership, no president, however formidable be his reputation or scholarship, and no official, however efficient or well-meaning, can make any law or perform any act which is not sanctioned by the Constitution. Section 2 of the Constitution expressly provides that law or conduct inconsistent with the Constitution is invalid, and obligations imposed by it protector as a citizen. It follows that any citizen adversely affected by any decree, order, or action of any official body which is not properly authorized by the Constitution is entitled to the protection of the courts. No parliament, no official, and no institution is immune from judicial scrutiny in such circumstances. What does that mean? In simple English, what that means is that the good intentions or the entitlements of the actors per se into the fact that they are doing their job, so to speak, is mightily irrelevant to the constitutional inquiry. And as far as this inquiry is concerned, even the question of bona fides is also mightily irrelevant. And as Mohammed CJ says, even the best president ever to grace the earth, like President Trump, who thinks that of himself, cannot act cannot perform anything that is outside of the Constitution, because lawyers sometimes make these things to sound complex. The constitution of the country is actually the same as the constitution of a football club or a burial society. If that constitution says the meetings will be held on Thursdays, and you hold the meeting on Tuesday, then you have breached the constitution. Irrespective, you might have had the greatest reason for deviating from the constitution. So similarly, if the constitution says you will give somebody who's adversely affected by a decision a hearing, which it does say. If the constitution says you will respect the rule of law and you will not misconstrue your powers, which it does say. If the constitution says you will act procedurally rationally in every step in a multi-step process, as the case of the DA and the president says, as NERSA says, which the constitution does say, you cannot do so. If the constitution says you cannot have an application, yes.
Mr. Pofu, please listen. This court has no quarrel with what you say and what the authority says that you've quoted in the decision of Muhammad. No, okay. We fully accept that. But you raised this in the context of Malafides, where in the very quotation, please listen, in the very quotation that you raised, it says the Malafides is irrelevant, the motive is irrelevant. What part B will deal with, is the constitutionality of the conduct and of the rules, and that we fully accept. The question that I had raised with you is the point that you raised was, what about the motives of the DA? My view, not I speak for the others, the motives of the DA in laying the charges is entirely irrelevant to the determination of Part B. I've not heard any authority in which you've been able to assist me, to assist this court in arriving at how do you get to the motive of the DA as being relevant to the determination of the constitutionality of the rules.
Yes, okay. I don't know if I have to read it again, but
please don't.
For what CJ was saying, instead of ANC, just put DA. So the point I was simply making when I was reading CJ's thing was, hopefully, again, I know the ANC is not the DA. So, but what I'm saying is that what Jay was saying is that in that particular case, on those facts of that case, the members of the ANC had prejudged the issues, and therefore, because they had done so, they were disqualified by the Nemo Udex. That's the principle. Okay. Now,
Mr. Pofu, before we spend a lot of time on this, the committee that needs to be put in place that will determine the findings in terms of the rules, that committee must be appointed by the Speaker. When the Speaker makes that appointment, there are rules of Parliament with regards to any member being conflicted. That member will have to declare. That's in terms of the exact rules of Parliament. Now, your challenge to the rules is that there's no mechanism in place in these rules that deals with the issue of conflicted or biased. What the respondents have said is that there are existing rules in Parliament to deal with that. Why must this court, at this point in time, in prayer 3, have to deal with the issue of conflict? But in any event, listen, in any event, the rules themselves must be read in context of the broader rules of Parliament, where there's already a provision. Please listen. There's already a provisions that deals with the responsibility of every member of Parliament to declare a conflict of interest when they exercise their roles and functions in Parliament.
Okay, I'm out. I'm not going to go there again. Honestly, last time that we spent almost half an hour on this.
Yes.
So I'm simply saying nemo iudex. I've never said anything about malafides. So your lordships, what you've just said. In fact, I was saying the opposite. That as far as this leg of the thing, malafides does not feature. And that's why I read Mohammed's, the lordship now says, I'm raising it in the context of malafides, which is the furthest thing I'm doing. So I don't want to, I really, honestly, let's move on to something else.
Okay, then can we accept, can this court accept that you're not raising the issue of malafides for the purposes of interim relief?
No, how can the court do that? I'm saying, we're talking about nemo iudex. Let's remember what we're busy discussing. Okay.
Yes.
Let's relax and let's. What we're discussing is nemo iudex in SUA, right?
Yes. In
the context of the rules of natural justice. That's why I said I don't want to be sidetracked into some debate about malafides. Okay. I'm saying as far as that, the nemo iudex leg of the fairness discussion, you must apply what Mohammed CJ said, which is devoid of any reference to malafides. It's actually the opposite.
Okay, right? I fully agree with you on that.
No, but okay, good. Now, I then say, if we accept that the bona fides is not an answer in this debate we're having now about which is really the only point I'm making, and then we accept that malafides is a discussion we had about outer. It has no place in what we're discussing.
Yes.
I have said in the first 10 minutes of my address here that malafides was only being raised in the context of ousting outer, not as a ground. I remember you wrote a note, not as a ground of attack. Okay, now, but be that as it may, even if, let's forget about the malafides of the DA, because really, let's just confine ourselves to the malafides, not malafides as such, the bias.
The issue is one of bias. No, Mr. Mpofu, I fully accept that you're dealing with the issue of bias in the context of the DA.
Bias.
That's what you've done. Now, all I said to you, that bias in the context of the DA or anybody in this process is dealt with by the very rules of Parliament that requires such persons to declare a conflict or a bias and may not participate in proceedings if there is such a bias. And the point being made, please listen, the point being made about bias is that Parliament already has rules to deal with it.
Okay. Let's move back. Do we accept that one of the persons that we say are biased in our papers is the Speaker?
That's what you say. And I
No,
and
yeah,
then
that's what we
you
say.
say
That's
that.
exactly what I say, our papers. I mean us. Yeah.
Yes.
Yes.
But
Okay. Now, if you
no,
accept that, let's put the DA on the side for now. If you accept that two of the parties that were
yes,
accused, rightly or
yes,
wrongly, was the president, the
yes.
speaker, and the DA. But let's put the DA on ice for now. The
Okay.
president, of these two that are remaining,
Yes.
the president has conceded to a reasonable apprehension of bias based on the fact that he is involved in litigation. He
Yes.
specifically says he does not accept that he is biased on the basis that there were adverse findings against him. But he
Yeah.
says only on the limited basis that he is involved in that litigation. And
Yes.
that's why he says that bias will or conflict will expire, which is not necessarily correct, will expire once the judgment is passed. But let's put that aside. All I'm
Yes.
saying to you, my lord, is that on that same bias, not the DA type of bias, on that bias of being involved in litigation, I'm saying that same bias applies to the speaker. I've already addressed that point. Whether it's accepted or not by the court is a different matter. But
Yes. Okay.
this is what I'm saying now about the DA, apropos that proposition. Forget about the prejudging and what have you. The DA itself, it is common cause, is involved in acrimonious litigation against the public protector, which is currently in the SCA regarding the spy allegations. That's common cause, right? Now, all I'm saying is that that species of bias, not the one of prejudging, the species of bias which the president has considered to I'm sorry, I'm sorry, Ms. Bauer. I don't want to put it higher. The reasonable apprehension of bias, because that's all he has said. That species is the same, taints the speaker and the DA in the same way. Yes, and I don't want to debate whether that other case of Musasa is different from the case of the spy allegations. I know that. I'm simply saying the species of bias that taints the DA is not confined to the prejudging of the matter, and also of all those people, which is what Chope CJ was saying. Nobody can prejudge, can judge a matter if they have if there's a reasonable apprehension of bias on their part. I mean, that's simple administrative law. Now, it's either those those biases, which are common cause, by the way, qualify as a basis for the application of the Nemo Udex rule, or they don't.
Yes.
Or they're likely to succeed or not succeed in Part B, or they're not. Full stop. That's all. There's nothing more I can say about that. So it's either the court will either say, yes, these grounds are likely to succeed, whether it's the abdication of responsibility, whether it's the legal representation, and whether it's the Nemo Udex. You're spoiled for choice. You can choose anyone. All of them are fatal for, you might not like a one and like the other one, that's fine. But all of them are fatal to the constitutionality of the thing. And that's why I don't want to spend too much time on that, because all three are fatal. If one of them is more fatal than the other, well, so be it. The next issue is rationality. That's the other ground which I say is likely to succeed. We've already touched on this in the context of failure to apply the mind, and so on, and misconstruing the powers. I now want to deal with it in the third sense of procedural irrationality. Procedural irrationality means simply this. It has been explained by our courts. Your Lordship knows about the NERSA case. But my favorite in this one is DA versus President of the RSA. The Lordship will remember the previous bundle of authorities.
I'm going to keep quiet now.
At page
We're with you,
56.
yes, we're with you, Mr. Mbovu.
I'm sorry.
I'm conferring with my colleagues. They're worried about time.
Yes.
So I've assured them that I will ask less questions.
Thank you. I'm heartbroken, Mala, because the engagements are quite useful. But yes, at paragraph 33 of the DA versus President of the RSA, which is a decision of the Constitutional Court, 2013 bracket 1 SA 248. And here, the notion, my lord, is simply the question of whether you need rationality at one step of a process or the whole process and so on. The Lordship is familiar with that discussion. This in Albut, in all these other cases about procedural irrationality. It actually started in Masetla and progressed to Albut. There's also the case of the Law Society of the Transvaal or something, which was more recent. But this is the best formulation of the Constitutional Court. It says the Democratic Alliance, NOHAL, submitted that the irrationality ground covers irrationality in process as well as on the merits. The Minister and Mr. Simenelan did not appear fervently to embrace this proposition, but did not advance any cogent alternative submission against it. And then it says, it at 34, it follows that both process by which the decision is made and the decision itself must be rational. Albut is authority for the same proposition. That the means there were found not to be rationally related to the purpose, because the procedure by which the decision was taken did not provide the opportunity for the victims of their family members to be heard on all four. So the DA argued in that case before the Constitutional Court that we must not just look at the outcome, we must look at the means, the process itself, so and rationality throughout the stage. And says, and while, and then said Mr. Simenala points out that this case is not concerned with pardons. That's the whole thing about the two cases, the facts will never be the same. Yeah. He argues further that the case involving pardons are distinguishable from the present case, same thing. While I agree that this case is not concerned with pardons, there is no basis for the suggestion that the proposition in Albut that decisions by the president as head of state should be rational, both in process and in the final decision, should not apply here. It is true that the decision of the president in this case was made ahead of the annex, whatever. It is illogical to suggest that while decisions by the president must be rational in process and outcome, but decision of the president as head of state should be rational only in outcome and not in process. And then the court says, this is the part I think we've cited in our heads. The conclusion that the process must also be rational, in that it must be rationally related to the achievement of the purpose, that's paragraph 36, my lord, for which the power is conferred, is inescapable and an inevitable consequence of the understanding that rationality review is an evaluation of the relationship between means and ends. The means for achieving the purpose for which the power was conferred must include everything that is done to achieve the purpose. Not only the decision employed to achieve the purpose, but also everything done in the process of taking that decision constitutes means towards the attainment of the purpose for which the power was conferred. What's the relevance of that in the present case? And it says here, the parties were ultimately in agreement that while each and every step in the process resulting in the decision need not be rationally viewed in isolation, the rationality of the steps taken has implications for whether the ultimate execution is rational. simple. It doesn't need explaining that. All it says is that if you find irrationality in many steps along the way, including, for example, in the in-order decision of 129 R, S, and T, then the test of procedural irrationality is likely to succeed. We must always come back to that. Is what we're saying here likely to succeed or not in Part B? If it is, then interim relief is competent. Then we go to the next topic, which is retrospectivity. Here, the issue is very simple. Fortunately, again, this was articulated by that court, this court, in the case of MEC. It was actually articulated by an acting judge in this court, in the case of MEC for Economic Opportunities, Western Cape versus Auditor General of South Africa. The reference, my lord, is 2020 bracket 1. No. That's NERSA. Oh, yes, I've got it. 2020 bracket 3, all South African reports. What's the page? 524C. It was a judgment by Foss AJVOS. And he says that paragraph 43, the constitutional principles of reliance and rationality do not permit government to create a situation in which the subject, including another organ of state, as in this case, reasonably expects that government will deal with a matter in a particular way and acts in that expectation and then changes its position at a time when it is too late for the subject to tailor its conduct accordingly. That is what occurred in this matter. The AGSA, Auditor General, took a decision which operated retrospectively. That is wrong. The audit findings cannot stand. That was a manifestation of the retrospectivity rule a la rationality. Because the retrospectivity rule is not just a rule in the air. It has been elevated from a presumption, which it was before 1994, to an element of rationality. And that proposition was again said by the Constitutional Court in the case of Phahla, PHAAHLA. That case you'll find in our list of authorities, but not in front of you, my lord. Minister of Justice and Correctional Services, 2019 BCLR 795CC. It was a judgment of Dlodlo AJ. Looks like the acting judges, he was acting in the Constitutional Court, have something to say about retrospectivity. And in that court, Dlodlo said the following, Dlodlo AJ, it is important to appreciate the self-standing pedigree of Rule 35.3N, which codifies that rule, because the various meanings of application it holds as constitutional embodiment of the nulla poena sine lege, no punishment without law. As an expression of legality, it prohibits punishment that has not been clearly set out in a statute, and so on and so on. Again, that's paragraph 65. And then it says, as an interpretive presumption, Section 35N has been applied to resolve ambiguities in sentencing legislation in favor of prospectivity rather than retrospectivity. Now, here's the thing, my lord. In this particular case in front of you, the only defense that has been proffered against this ground of rationality has been that the rules are merely procedural in nature. Now, nothing could be further from the truth, because I took your lordship to, the lordship must just go to page 470. 6 and tell me that this is a procedural provision. And here again, I'm shying away because last time we went off a tangent about incapacity. So I'm not going to mention the word incapacity because the same point can be made easily. The point I was really making, as I said last time, was not about incapacity, it was about retrospectivity. And the simple point was this: a rule that gives you the definition of a crime, and again I'm using that loosely, cannot be called procedural, right? Let's first agree that I think it's paragraph 138. Just 1 second, Malone. All right, I can't find the exact passage, but somewhere in chapter J's judgment in the EFF case, it says, and again, I think Mr. Breitenbach relied on that paragraph, so it's not in the minority judgment. In the judgment, in the majority judgment of chapter J, he said that it is the National Assembly and the National Assembly alone which must define the ambit of the transgressions, if you know what I mean. The transgressions that are outlined in section 89 of the Constitution. Oh yes, it's paragraph 177 of chapter J's judgment. It says, it is evident that the drafters left the details relating to these grounds to the Assembly to spell out. But the drafters could not have contemplated that that first sentence is enough. So in line with that, what these drafters did was to then define at page 476, let's run away from incapacity, let's go to misconduct. It then says misconduct means the intentional or gross negligent failure to meet the standard of behavior or conduct expected of a holder of public office. In other words, it's saying the misconduct that is referred to in the Constitution means these things. These are the elements. Incompetence, it says the same thing. Incompetence means lack of knowledge to carry out, the ability of skills to perform, and so on. Anybody who tells you that that is a substantive, I mean a procedural provision, is either smoking something or doesn't know the difference between substantive and procedural. So these rules, that defense, quote unquote, on the retrospectivity point, based on the fact that these rules are merely procedural, must just be thrown to the dustbin. And therefore that as a ground of irrationality must stand, or go back, is likely to succeed in part B. The last one is separation of powers ground. Here I need to say this to the court. This ground contains two overlapping issues. One is rationality, the other one is separation of powers per se. Let me explain how. If you go to the three important cases, it's too late now, I'll not go there, is Sapil versus Heath, and NSPCA, and Amabungane. All those cases say very clearly that it is undesirable for a judge to participate in, I'm sorry, yes, in what is sorry, I'm just looking for the right expression. Yes. In Heath, it was said that if if the function is not appropriate to the central mission of the judiciary, then the courts must not get involved in anything like that. And it says that one of the things which I highlighted, you'll remember, my lord, and my lords and my lady, is that here it's even worse because judges are meant to be appointed by politicians and political parties, which mires them into political controversy. This is what the court accepted in Heath, paragraph 29. Mr. Trenbov, again, sought to distill from these authorities certain criteria which he submitted are relevant in considering whether or not, under our constitution, it is permissible to assign non-judicial function to a judge. They are whether the performance of the function A is more usual or appropriate to another branch of government. Well, clearly here, the National Assembly's job. B is subject to executive control or direction. Again, this is even not just direction, the appointment by the National Assembly. And then C, which is the one I'm going to, requires the judge to exercise a discretion and make decisions on the grounds of policy rather than law. And then D, creates the risk of judicial entanglement in matters of political controversy. And then involves the judge in the process of law enforcement, will occupy the judge to such an extent that he or she is no longer able to perform his or her normal judicial functions. I just want to talk about C and D. Political controversy. It is undesirable for a judge to be involved. This is the biggest irony of this case, by the way. These respondents speak with both sides of their mouth, because when we talk about Section 34, the applicability of Section 34, they say, no, Section 34 is not applicable because these are political decisions. They're not necessarily legal decisions. Section 34, as we all know, applies to those things that must be resolved by the application of law. That's what they say. And then they forget that submission. When they come here now to separation of powers, we say you can't involve a judge in what is essentially a political decision. They say, no. It's not a political decision. It's a decision of law. That's why you need a judge. You can't have it both ways. They must decide. If it's a decision that is political, essentially, then the judges must be kept far away from that. More putting aside even the fact that you get appointed by a political party. And therefore, the rules are fatally flawed and unconstitutional for breach of the separation of powers rule, and it's likely to succeed on that basis alone. But in this case, it is even worse because the speaker, who, according to these rules, has assumed the powers to appoint a judge, does not have such powers. So it's a rationality issue as well. She's acting ultra vires. There is no power anywhere in this world that I know of. We know the case of Factual. Your Lordship knows that case, where Chaskalson said a functionary may never perform any function or duty that is not authorized by law. It's not done. So I asked the question and nobody answered it. I asked it deliberately so that my learned friends in reply, when they were answering should tell us, where does the speaker acquire the power to appoint a judge? There was no answer because there's no answer. It's unanswerable. It's worse that she even wants to involve the Chief Justice in that illegality. Because now it says the speaker must appoint the judge and must consult the Chief Justice. We don't want our Chief Justice to be tainted by such illegality. I mean, I'm quite sure that that thing is just unlawful, both in its conception and in its so-called the Chief Justice, at least I know this much, is only a member of the JSC. He has no authority to appoint a judge. And I referred Your Lordship to the case of the President versus Public Protector, how the Zondo Commission was appointed. And it was made clear there that the Chief Justice cannot appoint anybody. But here's the real reason, my lord. It's in the Amabungane case. At paragraph 66, started 64, says the proposition that the ministerial role in the appointment, and again, I know this was a minister, not the speaker, but it's the same principle. That ministerial role in appointment of judges to serve on commissions of inquiry serves as a useful comparison is inherently misconceived. That's the defense that you have been given here, that this is the same thing as the appointment of judges by the president to serve on commissions. The learned Judge Sutherland said that is misconceived, and he was correct with respect. Says, the present appointment process of the designated judge is plainly on the wrong side of history. The remedy suggested is that the JSC should appoint the designated judge, and indeed appoint not one but a panel, but such means is argued the judicial flavor of the appointment can be assured. At least that was correct. I mean, I don't know if the JSC would accept that, but at least the JSC is a body that is constitutionally empowered to appoint judges. So that was in the right direction. But here's the real issue, my lord. Says that this is paragraph 66. It is argued that it is appropriate that a similar approach be applied in the case of a designated judge. Here are the important words. The appointment must not be capable of being perceived as a sinecure that might induce, if only subliminally, an appetite to appease. That's first-class English, but it simply means, so the appointment must not be capable of being perceived as a sinecure that might induce, if only subliminally, the appetite to appease. In my normal language, it says that appointment must not give the impression to the public that the judge might be partial to a particular political party, for example. Why is that so? Because let's think about it. My learned friend, Mr. Shabalala, will be a judge one day. So if Shabalala J is appointed by the ATM, ABC XYZ party, and is nominated now to sit in judgment of the public protector. And we all know that he has been nominated by the ATM. The following week, he has a case in front of the same judge where the ATM is a party and the other party loses. They're going to say, well, what did you expect from the ATM judge? Because Judge Shabalala, you remember, was nominated. That's what is meant in Heath by saying a judge should not be exposed to a situation where there might be any political controversy, so to speak, particularly in a matter that is already controversial, such as this one. So again, is that argument likely to succeed or fail in Part B? I would say it's self-evidently likely to succeed, both in the lack of the undesirability of appointing a judge and the absence of powers of the public protector. My lord, this is what I'm going to do. I'm really going to round up now. I will not go in what I have said. I have covered in a way the section of what I call the Q&A in last week's submissions.
Mr. Wolf,
I'm sorry, my lord.
Yes.
I thought she was intervening.
Yes. You would recall that when Mr. Breitenbach and Mr. Butland presented, there was an issue that the court raised with them, and that was a conceptual issue about the nature of the decision to be taken by the Section 194 committee, which is essentially what they've argued a political decision.
In one section here.
Yes. And the issue that the court raised to them, should the investigative process not be by an independent structure, as opposed to the very same people who are investigating and then making a decision. And that is effectively what the 194 committee would be doing.
Yes.
Now,
yes.
I'd like to hear your view on that.
Yes, my lord.
As you will recall that even during the deliberations of the Rules Subcommittee, there was much debate with regards to the role of the panel and its relationship with the National Assembly or the 194 committee. There was even a view expressed that perhaps the panel should make findings or conclusions on the various charges, and then they make a recommendation for the 194 panel, such that the 194 committee to consider in a political context, and then to make findings of a political level. And that was part of the debate, and it seemed to have gone both backwards and forwards, and even in the various options that were given to the Rules Committee at some stage. There was even a view expressed that perhaps the independent panel should play a role within the 194 committee. That, of course, was not accepted, and that's why it wasn't included in the final draft that was presented to the committee, to the Rules Committee.
Yes.
So I'd like to hear your view on that conceptual issue.
Yes, very briefly, my lord. Your lordship, yes, I remember that point. Let me just start by saying, my lord, firstly, I have, or at least we, for the public protector, have no conceptual difficulty with the idea of an independent assessment of whether it's the prima facie or the other stage of whether the elements of the offense have been so I must not be in my attack on the composition of the independent panel. I must not be understood to be saying that the principle of that independent sifting, as Mr. Breitenbach calls it, is wrong. I'm confining my attack on the issue of involving judges in that process. In other words, it can be done independent, as it was said in Heath. Judges are not the only people who are independent in the world. So you can achieve the purpose of independence without necessarily breaching the separation of powers rule. So let me put that to bed so that I'm not misunderstood. Coming straight to your lordship's issue, we accept, my lord, that the court is not allowed actually to configure and say, well, you must do it like this, you must do it like that, because that encroaches on the separation of powers. Yeah. The court's role is only confined to this. Is the method that is actually chosen, in this case, the inclusion of the judge in the panel, so on, constitutional, yes or no? So that's what I was trying to explain the other day. The court's role is not to answer the question how. The court's role is to answer the question whether. and chapter J has been at pains to explain this in EFF and in the EFF Godan and the other cases, that the court's role is not interfering to say whether that something is constitutional or not. It's actually the court's job. It's the court mandated and is obliged to do so. So the court in this case should say whether the means adopted here are constitutional or not, and stop there. As to whether the model 1 or model B, or maybe we can do it like this, maybe they should do it at the stage of prima facie or final, that's not for the court. The National Assembly must sort that out once the court has said that this one is not constitutional. So that's the first answer. The second answer, my lord, is that, and it deals with another point that was raised about why I'm saying people should be recused when they have not been cited or named. You can't name people who are not there. Again, it was a matter of principle. We're saying when the Section 194 committee is appointed, those people who have said that she must resign and she must do the right thing and what have you should be excluded, and who have prejudged the issue. It goes back to the question of Nemo UDEX, and that's what Hlope J was trying to explain. So those members, you can't name them now. You are simply saying the danger is that those kinds of people might end up being in that committee, for example, in the future. Not so you can't name them because you don't know them. But anyway, that's an aside. Anyway, that's the answer to that proposition, my lord. Then, my lord, if you allow me, before your lordship maybe might want to follow up, just before I forget, your lordship also raised the issue with Ms. Bauer about whether when the suspension stage comes, Audi will be allowed or not. If I can address that very quickly. Your lordship was quite correct to raise that, because that's a concern that the court should have. But I agree with Ms. Bauer that that process, we have to assume that the president will do the right thing. And Ms. Bauer rightfully said that at that stage there would be Audi, whatever the form of Audi might be, whether it's a representations or a hearing or whatever, that's for the president to decide. And I think that that's a very important intervention by your lordship, because while we concede that these rules could not have said when the president is going to suspend, he must give Audi, because then it would be the other way around. It would be the National Assembly encroaching on the executive's terrain, so to speak. But it must be assumed by all right-minded people that that is understood to be the case, and that's comfortable for the public protector. So we don't take the point that the rules are deficient because they don't spell out that the president must give Audi. Firstly, because of what Ms. Bauer said on that question, but also because, as I say, to ask for that would be, on our part, actually doing the exact opposite of what we preach, which is that there must be a separation of powers. I just wanted to address that very quickly. But your lordship, going back to section 194, I don't know if I answered your question.
Yes, can I also just get clarity on one thing? The last time we raised this, the applicant has got no objection to an independent panel playing the role as envisaged in the process, other than the appointment of the judicial officer.
Yes. In other words, what we're saying, my lord, is that and again, I'm not answering your lordship directly. I'm merely saying, leaving open now the question whether the section 194 or the panel is going to decide which issue, which, as I say, is in the hands of the National Assembly. What we're saying is that the idea, the idea, we can't, by the way, because even in the EFF case, the impeachment case of the president, it is envisaged, even in the minority judgments, all the judgments agree that at some stage there needs to be an independent verification, or maybe not independent, but objective, which usually requires independence, an objective assessment. In the case of the president, for example, of whether the violation was serious or not. And all the judges, minority or majority, say that that must happen. The only difference they had was whether in that particular case, you remember Mkhweng CJ and Zondo DCJ said it was not necessary to do so in that particular case because already the parties had already pronounced on it. And therefore they were not under the Nemo Udex rule.
The minority view.
Yes, no, but all the the minority view on the last point, yeah.
Yes.
The Nemo Udex rule is a view. It's not. It is not. Yeah. So anyway,
why I've raised that is that somewhere in the papers, and it might be in either the affidavits by or in heads of argument, one of the objections to the judge is that he is an unelected person.
Yes.
So if the judge is unelected, does it not apply equally for the other members of the panel, or is it accepted that other than the judge, other unelected persons can also participate in the process?
Yes, no, that's a fair question, my lord. That proposition, your lordship is quite correct, has two legs. The first leg is based on what Chapter J says in the EFF, where he says many times, it's the National Assembly and the National Assembly alone. You'll remember he says that that refrain is I'm sorry, my lord, I'm just looking for the. I'll find the passage.
Yes. Okay.
So your lordship is quite correct. So there is that aspect of it whom does the Constitution place this power? But I think, my lord, with the greatest respect, one should not take the issue of separation of powers is really about the arms of the state inter se, if you know what I mean, as among each other. But that principle cannot be now extended to say that one of those arms, whether it's the executive, whether it's the legislature, or whether it's the judiciary, may not then delegate a particular function in its own right to experts or whatever. I think actually the executive does that every day, the consultants and all sorts of people. But they can't delegate to the National Assembly, for example, or to the judiciary, or vice versa.
Well, the important point, Mr. Both, as I understand it, the independent panel doesn't make decisions that impacts directly on the applicant. They only form a prima facie view, which then gets referred to the National Assembly.
No, that's wrong. I'm sorry, my lord. They do make a decision. You remember?
They make a prima facie finding. They don't make a decision against.
Yes.
Or they make a prima facie finding.
Yes, my lord. No, that is why, if you remember, the speaker actually, interestingly, said this in one of her press releases. When Ms. Mazzoni brought a new motion, she said, I'm now going to, under section 129R or T, I'm now going to make a fresh decision. So she knew that she was making a decision in the legal sense of the word. Similarly, the independent panel makes a decision of finding. I accept that it's not that's the whole point of the NERSA and the DA case. It's not the final outcome, but in its own right, it's a decision. That is why she's given Audi in front of the panel, because that's a reverse acknowledgement of the fact that they have to make a finding. Hence, she's given Audi in front of the panel. And that's why we criticize the speaker for not giving her Audi when her decision is made. So this is a series of decisions culminating in the outcome. So in the legal sense of the word, my lord, I know what your lordship did not mean it like that. Your lordship meant that they don't determine the final outcome. But in the legal sense of the word, they make a decision. In the Paja sense, if you know what I mean, they make a decision which may have adverse impact on a person. Blah blah blah. I can't remember the definition off by heart, but they make a decision, and that, my lord, by the way, takes us to. This is one of the most important aspects of the notes that we sent to your lordship last week. Your lordship will remember that at page 27 of last week's notes, and this is a crucial point. I'm glad your lordship has raised it, because I actually had forgotten to deal with it. About what actually attracts Audi. I know I'm not addressing directly what your lordship is asking, but at page 27 and paragraph 60, we quote the following case that was approved by our courts in Dupree versus TRC, of what is it that attracts the right to a hearing. And that court says, I'm afraid that counsel for the inspectors went too far. That was an English case. He did suggest that in point of law, the inspectors were not bound by the rules of natural justice. He submitted that when there was no determination or decision, but only an investigation or inquiry, which is what your lordship is saying, the rules of natural justice did not apply. I cannot accept counsel for the inspector's submissions. It is true, of course, this is Lord Denning says, it is true, of course, that the inspectors are not a court of law. Their proceedings are not judicial proceedings. They are not even quasi-judicial, for they decide nothing. They determine nothing. They only investigate and report. They sit in private. But this should not lead us to minimize the significance of their task. They have to make a report which may have wide repercussions. They may, if they think fit, make findings, there's that word, of fact which are very damaging to those whom they name. They may accuse some, they may condemn others. They may ruin reputations or careers, going back to the harm that we spoke about. They may ruin reputations or careers. Their report may lead to judicial proceedings. It may expose persons to criminal proceedings or civil actions. Seeing that their work and their report may lead to such consequences, and the Constitutional Court says potential consequences. Seeing that their work and their report may lead to such consequences, I am clearly of the opinion that the inspectors must act fairly, and Audi applies. So the mere fact that the independent panel makes findings which are a part of a process, which is even worse than what is postulated in that in here, because here they say they decide nothing, does not mean that we should minimize their role.
Still here with us at this late hour is to them leaving, because it's much past the hour of having to leave. Okay, I'm listening to you. I can multitask, Mr.
Yes, no, I'm done, my lord. I was just distinguishing. I was distinguishing between that objection, as I say, which we don't raise, about the independent panel, as it were, usurping the functions of the National Assembly. We don't raise that point.
Okay.
If we did somewhere, then we're abandoning it. The point I'm making is simply this. The objection, the real objection for us, the unconstitutionality, as far as the panel is concerned, is the fact that it breaches the constitutional rule of doctrine of separation of powers. We don't go as far as to say the NA must literally do the work on its own without delegating even someone to make photocopies or whatever. No, we accept that in doing its functions, it may delegate some, particularly here in this case, we accept, my lord, without any reservation, the fact that in this case, there's a need for a sober, maybe that's the wrong word, an objective determination of a fact. And that is not something that politicians are necessarily skilled in doing. Just as if there was going to be a determination of whether money disappeared at the right time or not, the National Assembly might get accountants to determine, just say, look, this is all figures, they look all the same to me. But can you tell me if any money was stolen here? And then they say, yes, it was stolen or not. And then they do what they have to do. Surely, I mean, it would be unreasonable for us to deny that. So we accept that, my lord. What we shy away from deliberately is to answer your lordship's question, which is whether that independent determination is properly done at the prima facie level or also at the committee level. Your lordship's guess is as good as mine. And the National Assembly must decide that question on its own. But it's a valid question.
Whilst we're on this, can you just assist the court with the applicant's understanding of what is the difference, if any, on the applicant's understanding of the role that the speaker plays in accepting the motion as being in order and the independent panel? Is there a difference in their function with specific reference to the rules?
Thank you, my lord. Yes, my lord. My lord, we approach it on the same basis as Mr. Breitenbach, that there is a double sifting mechanism. And that double sifting mechanism is of course, remember what we're dealing with here is a punitive statute, provision. Remember, my lord, at paragraph 138 of the impeachment case, EFF, Drafter J, when he was contrasting section 102, which is the motion of no confidence, with section 89, had this to say. In contrast, the removal of the president, let's say here public protector, by means of impeachment is subject to certain conditions. It must have as its foundation at least one of the grounds listed in section 89(1), 194. And the impeachment itself must be supported by a 2/3 majority. Then he says the reason for this distinction in process is that impeachment is punitive. Depending on the ground on which it is based, the impeached president may lose all the benefits and be barred from occupying office, blah, blah, blah. So to answer your lordship's question, the starting point is to appreciate that we're dealing with a punitive measure. So that's why I made that example of the criminal process. You have multi-staged sifting processes. And I made the example, for example, between the decision, the prima facie decision that is made by the prosecutor, which is reviewable in its own right. We know that some of those decisions have been set aside and what have you. And contrasting that decision with the same prima facie decision that is made by the court at the stage of 174 application. Those are both sifting mechanisms in a particular process. There's still the decision of guilt or not guilt at the end, which is a different decision. So, but as in the example of the prosecutor, what we are arguing, my lord, with the greatest respect, is that in as much as in the second sifting mechanism, Audi is provided correctly, it should be also provided in the first one. In other words, what we're saying is that, to answer your lordship's question in shortly, is that the assessment of the existence of a prima facie case as to whether the provisions of section 194 have been met, in other words, misconduct, incapacity, and so on, is essentially the same. It might be for different purposes. When it comes to the speaker, it is the trigger mechanism by which she can go to the next stage, which is the appointment of the panel. Without that trigger, the process stops right there. In fact, 129S says that if she's not happy, she thinks it does not comply, she must send it back to the member, and so on, until she's happy. 129T can only kick in once she has done the assessment of constitutional compliance, and so on and so on. Whereas as far as the panel is concerned, it's the same thing. The panel, remember, makes a recommendation. So the panel's one is weaker in a way, actually. It's even less dangerous than the one of the speaker. Because the one of the speaker then sets the whole thing in motion. Whereas the panel only makes a recommendation. The National Assembly might say this panel is mad. We don't think there's a prima facie case. So if you look at it objectively, the speaker's decision has a much more serious impact, adverse potential impact on the public protector than the decision of the. But qualitatively, they are the same, my lord. In fact, the wording, your lordship will see, the wording is almost identical. I know Mr. Breitenbach tried, and I think even he couldn't go as far as to distinguish between. Let's go to 477. Your lordship will see at 129R2 says, provided that the motion must be limited to a clearly formulated and substantiated charge on the grounds specified in section 194, which must prima facie show that the holder of a public office committed misconduct, incapacitated, is involved. If you then jump to 129X1B, you'll find that it's almost identical. It says the panel must, within 30 days of its appointment, conduct and finalize a preliminary assessment relating to the motion proposing a section 194 inquiry to determine whether there is prima facie evidence to show that the holder of public office committed misconduct, incapacitated, is incompetent. The same thing. They do the same thing, but for different purposes. That's why Audi is prescribed in both.
And then just on that point, on that, what would have then been the purpose of the National Assembly making the amendment to Rule 88?
Rule 88?
Yes.
Perfect. Thank you, my lord. That's, how can I forget? That's my favorite point. That, my lord, shows exactly what I'm saying. Remember, go to page 480.
Yes.
And you'll be surprised. Firstly, look at the motivation, for amending Rule 88. The last sentence, it says, given the proposed Rule 129R to 129AF, the Rules Committee recommends that the following consequential, that's the most important word, consequential amendment to Rule 88 should be made. Consequential means that it's because of those rules. And then look at what they take out. They say that no member may reflect blah blah blah, and whose removal from the office is dependent upon a decision of the House, except upon a separate substantive motion in the House presenting clearly formulated and properly substantiated, very important, charges. And then now the new rule stops there. But let's look at what they are taking out. They take out the following words, which, if true, would, in the opinion of the Speaker, prima facie warrant such a decision. There's your answer. In other words, they're saying that which was served by those words is now being served by 129R. So, and again, if that one is even clearer, which if true, in other words, it's a serious assessment of the merits of the charge, so to speak, the real prima facie assessment, would, in the opinion of the Speaker, that's a decision, discretionary decision. Prima facie, we know what that means, warrant such a decision to remove, in other words. In other words, the Speaker was, by Rule 88, empowered to make a decision that the removal is prima facie going to happen, so to speak. Those are my words now, not the one. That it's prima facie guilty, let's put it like that. But now they say, because we have 129R, which provides essentially for the same thing, there's no need for those words to be repeated again in Rule 88. That's the clearest example that the stuff that the Speaker does under Rule 129 R1A is serious stuff. It's a major decision as to whether, in her opinion, if the allegations were true, there would be prima facie removal. So that's thank you. I'm glad your Lordship pointed me there. That was the point that I had intended to make. So there's no doubt, again, as I say, that decision is more dangerous, I'm using the word loosely, to the accused person than any decision that the panel might make, which is a mere recommendation. It's like what
Mr. Mpofu, you frozen? No. Mr. Mpofu? You frozen on our side? Okay, let's just check with the other people. Mr. Breitenbach, Ms. Bauer, Ms.
We're still here, Judge, so we think it's Mr. Mpofu.
Yes. Still here? Is Mr. Mpofu also frozen for you?
Yeah.
Yes.
Yes, my lord. I won't say thankfully, but
we think it's a subliminal message coming through the airwaves.
Don't stretch your luck, Mr. Breitenbach.
Ah, there you are back, Mr. Mpofu. Thank you. Good.
I heard that. But yeah, I hope you didn't hear what I said when I was frozen. But anyway, so, but I was saying, my lord, yeah, I think I've answered the question. I was saying that it shows that it's a more dangerous decision than the mere recommendation. And I was making the example between binding remedial action, for example, as opposed to mere recommendations.
Okay, good. Mr. Mpofu, where are you in your roadmap?
I'm almost done, my lord.
Oh.
I'm going to, as I said, I'm going to skip the 12 Q&As because those are covered in what we discussed in the four The last point, my lord.
Yes.
And this is just a sweeping point. I have done in the current notes. Your Lordship will see, because again, I think there were some terminological issues that I wanted to highlight about the meaning of bias from a legal point of view, as opposed to in layman's terms, so to speak.
Yeah.
Malafides, we deal with that. We show that malafides there are quotations that show that it has been used interchangeably with not applying your mind, for example, and so on. So it's not an insult. In everyday language, malafides means bad faith, which connotes some kind of funny business. Okay. Now, in legal terms, malafide, an allegation of malafides does not necessarily entail that, and that's explained again in the cases and also in the literature, as well as then this one, nuisance value. The DA seems to think that nuisance again is used in the everyday language. It's not used in that sense. It's even in the everyday language, by the way, one of the synonyms of nuisance is inconvenience. So we were saying that if we've already had this debate, if you know, if the expedience is what chapter J calls expediency, if you know that the outcome is not going to eventuate, then the only purpose you serve is short-term expediency or inconvenience to the person, and nuisance in that sense. And the Oxford Languages gives the definition. It says an act, nuisance is an act which is harmful or offensive to the public or a member of it, and for which there is a legal remedy. So that's exactly what we're talking about. And then nuisance value obviously has a corresponding. Then we very quickly we go to the difference between procedural law and substantive law. I've already made that point, and we use the example of criminal law, which defines the offenses as opposed to criminal procedure. And then we talk about what the other issue, the debate about what we meant by the sobukwe clause, which was also, with respect, misunderstood. What we meant by that is, and we
don't want to go back there, do you, Mr. Mpofu? You really want to go back there?
I do, for the sake of correcting it. And I'm doing it because this is not Mr. Mpofu now speaking. This is something called the Long March to Freedom News of Cape Town. You'll find that at paragraph 45 of our the latest, because it was misunderstood in two ways. Firstly, as to who it was referring to, which was the DA, not this government, and also the meaning thereof. This is what it says. We say. We say the record will show that, you know, in any event, if anybody Googles the phrase Sobukwe clause, one will come across clear explanations thereof, including a useful article by Long March to Freedom, Cape Town, entitled Sobukwe clause, which inter alia and correctly states that, quote, due to his influence in the struggle, the apartheid government enacted the Sobukwe clause, a statute to authorize the arbitrary extension of the Sobukwe's imprisonment. The clause was also known as the Sobukwe clause since it was specifically aimed at keeping the PAC leader Robert Sobukwe in jail, also later admitted by the government. This is a 3-year change. He was actually detained for a further 6 years in annual decision of Parliament. Now we say the simple point being made with this analogy was that the DA's draft rules, for example, which were submitted as draft rules for the removal of the public protector, were obviously intended, and the DA doesn't deny this to its credit, specifically for Advocate Mkhwebane. It is to the credit, not discredit, of Parliament that these rules were defined more generally, at least at face value. Left to their own devices, the DA rules were nothing but a typical example of a Sobukwe clause as defined in the article. In other words, moving from the analogy to the concrete rules, the legal point is that such a law could only be valid under an oppressive and parliamentary or Westminster system, but never under constitutional democracy, such as ours, which is exactly what Parliament corrected. You cannot have a law under a constitution which is targeted at a particular person. And that's why Parliament, in its wisdom, correctly, in September 2019, expanded the rules to be the rules about the removal of Chapter 9 institutions in general, as opposed to the Sogbuke clause type, which was envisaged by the DA initially. And we make that submission. It might be a good submission or not a good submission, but the point is that in a constitutional democracy, it would be impossible now, for example, to enact a law such as the Sobukwe clause, because it would be ipso facto irrational. Whereas under the Westminster system of a parliamentary democracy, it was putting aside questions of oppression. It would have been possible because Parliament was supreme. Here, in a case like this, it would be struck out by a court the following day. Yeah. But anyway, those are just some of the issues that we make those clarifications, not so much to make them, but to, insofar as there was some reliance on those terminology to ask for punitive costs. It's just because of failure to understand the legal meaning of the words that were employed, and so we assist in that regard. So, for example, it might be punishable to say something is a nuisance in the street if I'm talking to my friends, but in law it means an inconvenience for which there's a legal remedy. And there's nothing wrong with saying that. All in all, my lord, your lordship now knows that there's an agreement about Part B, and that is that Part B will is going to happen in 2 months' time for all intents and purposes. Unfortunately, because of technology, this case is now almost dragged for the better half of August. So we're left with September and October. In the 3rd month, Part B will be heard. So the real question is this: apart from considerations of what I call expediency, vindictiveness, and wanting to see somebody suffer, or even the whole country suffer because it has no public protector, what is the harm? What harm is there to the speaker? Because we know that we can't say to the National Assembly, because I've already explained that the majority of the National Assembly is at best neutral, if not supportive. What is the harm of awaiting in a case like this, where there are unanswerable propositions, my lord, around legal representation, around separation of powers, around procedural irrationality, around retrospectivity, unanswerable, or at least unanswered propositions, which are more than likely to succeed, is the understatement of the century in this case. They are going to succeed, but 80%, because they're not answered, because courts don't work that way. You can't win if you don't pitch, so to speak. So insofar as those submissions are unanswered and unanswerable, the likelihood to succeed and it's all in the interest of all of us, by the way, that Parliament will be so much enriched, that's what the ATM says, by rules that have gone through the judicial scrutiny, where your lordship would have said, you don't have to exclude the lawyers, you must give Audi speaker, and so on and so on. That's to the benefit of the country, because we'll have, actually it will even, it's a double benefit. Even the Section 89 rules, which have not yet been tested after the Constitutional Court, will now benefit from this process, because this process will enrich our democracy. So what harm, possible harm, can happen in waiting for 2 months or so until the matter is resolved? My lord, I know I said it's my last point, but please allow me this. If you read, and I'll paraphrase it, if you read, this is now just for reality, one doesn't have to be a lawyer to appreciate this point. If you read the EFF versus Godin case, you will see there, my lord, that Justice Hampepe makes the point in saying there is no harm to the public protector. She says the public protector has given evidence here that she, the public protector, normally does not oppose interim relief if somebody wants to review her remedial action. That's the truth. So here's a public protector who has been, well, I won't say commended, but at least recognized by the Constitutional Court that it's at paragraph 22 of the Godin case, where they say the normality of this practice was considered by the Public Protector's Counsel, who acknowledged that the Public Protector did not ordinarily oppose interim orders of this nature. However, Counsel posited that the Public Protector was opposing this particular interim because she was insulted, what have you. So here's a person, imagine, my lord, here's an official whose policy, correct policy, is that if someone goes to court, I will hold back on my remedial action until that the rights and wrongs of that person have been determined. But when it's her, she does that to everyone. She does that to ministers, she does that to the president, she does that to all and sundry. But when it's her turn to be treated in the same way of saying, I want to benefit from the wisdom of the court, and therefore let's hang our horses, let's hold our horses until the court, then suddenly the rules must change. That's injustice, that's unfair, that is wrong, that is selective justice, that is justice that is going to be put for the people we hate and not for those that we like. And that, my lord, is not something that can be countenanced by our courts. It is just, it is correct that people should wait for the court to determine the constitutionality or otherwise of official action, because all these people, they're not acting personally, they're acting in their official capacities.
Yes.
It's not nothing to do with their
my brother is a question to put to you.
Yes, Justice Samela.
Yes, Mr. Mbofu, just I would like you just to make me to relax a bit. In your last 2 weeks replying address arguments notes, especially on page 3. Yes, paragraph 4.2.
I'm sorry, my lord. Let me.
Last week's. Yes.
Last week's one. Yes, I've got it.
Yes.
Page, my lord.
Page 3.
Yes.
Paragraph 4.2.
Yes, my lord.
And also you attached a draft order in the very same document.
Yes, yes, that's last week's one, yes.
Yes, but now I see then that you have got this alternative prior to above. What does that mean? Because that confuses me a bit.
Thank you, my lord.
Are you abandoning that, or are you still seeking for that relief?
No, my lord, I'm not abandoning it. Let me. I'm very, very grateful to your lordship for pointing that out. If your lordship goes to page 2 or 3 of the papers, and by the way, if I may just abuse this opportunity to clarify something else, which is that the retrospectivity prayer, you will see that it's reflected in paragraph 2 of part B. In other words, in its own right, it is also pleaded as an alternative, but that's not what your lordship wants to know now. If you go to page 2, my lord, what you are saying, my lord, in simple terms, is that if the court gives us the principal relief which we need, which is what we call the suspension of the implementation of the rules. Then there'll be no need to grant number 3. And the simple reason, my lord, is that if the process is suspended in the interim for the next couple of months or so, then the whole question as to who's going to vote this and that and the other falls away, at least in part A. I don't know if your lordship is with me. In other words, if the interim order is granted, then it doesn't matter if this one is conflicted or not conflicted, because all those issues will be debated in part B. However, and this is where prayer 3 becomes important. If your lordships and your ladyship do not grant prayer 2, then the prayer 3 kicks in, because remember now that it means the process is actually continuing. So we're in a different world altogether. It's not suspended. If it's continuing, we then say, then those members who have a conflict may not participate in the process. That's the relationship between the two. And that's what, again, I was misunderstood last week. That's what I meant when I say prayer 3, when we are still talking about prayer 2, is of academic interest, because it only kicks in, like all alternative prayers, if it depends on an if prayer 2 is not granted. I'm glad your lordship gave me a chance to clarify that. That's the relationship between those two things. So prayer 2 is granted, prayer 3 falls away.
Mr. Mpofu, just on that question,
Okay.
prayer 3 is then phrased as final relief.
No, it's not. Okay, remember the operating, I heard that last week. Part A, you must go to under the thing that says part A. The first words there say, pending the final outcome of the main relief set out in part B below, this court hereby grants an order. That means that everything that follows after that, 1, 2, 3, 4, is pending the part B relief. So it can't be final, because we're saying even before the constitutionality of the rules is determined one way or the other in part B, if this court says that in the meantime the process must continue, then this and that should happen. So it can never. I mean, it's just this idea that this final relief is wrong, plainly wrong, because it negates the operating words of those people who say that just read interdicting the respondents without reading the words that are operating, which says pending part B. In other words, once part B is done, that order goes away, whether win or lose in part B. I'm railing that to clarify those points. And then, of course, the other point were we said prayer 5. We abandoned prayer 5 because we say even though the speaker gave the wrong reason by saying she only looked at the form, but she gave a reason. It just happens to be a reason that is irrational. That is a confession to her irrationality. But we can't say she didn't give a reason. It's a reason. It's a bad reason, but it's a reason. So we abandon prayer 5, and then the only other point is that prayer 3 is of part B can be wished away. I explained that when I was explaining earlier, and that for the purposes of part A. In other words, whether prayer 3 was there or not, we would still be asking for the interim relief pending the declarator. That is good enough for part A and the suspension. And then prayer 2 of part B is a separate declaration that the rules do not operate with retrospective effect. The reason for separating that prayer is simply that that prayer Remember, Section 2 of the Constitution says law or conduct inconsistent with the Constitution is invalid. That prayer, we concede, does not go to the law itself or the rules. It goes to the conduct of both the DA and the Speaker. Because the DA could have put a motion about conduct, about misconduct that happened last week. That is nothing, that's not a criticism of the rules. It's a criticism of the DA's motion, which clearly says that it deals with, it actually says that from day one of it's at 485, says it is our submission that the conduct of the public protector since the beginning of her term in October 2016 has amply demonstrated that she is not fit to hold office she presently occupies. The conduct referred to, and then they say, so it's clearly retrospective. And then the Speaker accepted that defective motion. It's a defective motion. There's no other way of looking at it. And so the conduct of the Speaker in accepting a defective motion and the conduct of the DA in presenting a defective motion is what Prayer 2 is all about, the retrospectivity. It's got nothing to do with the rules themselves, because the rules don't say you must bring retrospective motions.
Mr. Mpofu, before you end, there's three very brief issues I want you just to give literally just a one-line response to. In your argument, you mentioned repeatedly to the notion of double jeopardy.
Yes.
And raise judicata. Now, the notion of double jeopardy was raised for the very first time by the applicant in her replying papers.
That's not true. Okay, let's go to the founding affidavit.
Show me in the founding papers where double jeopardy was raised.
Okay.
And also the notion of res judicata. Where was that raised in the papers at all?
Okay. Okay, my learned juniors, yeah, I thought that might come. My learned juniors are looking for the double jeopardy is pleaded. Can I show you?
It's pleaded in the replying papers.
No, that's not pleading. The founding papers must be in the founding papers. I'll find it. I promise you.
Yes,
but in any event, the notion is again very simple. It's the same argument really as the what J called the and Zondo's DCJ said that you can't be punished twice for the same thing, so to speak, or those who have condemned you cannot condemn you again. Like the court.
No, I think it's fundamentally different. The double jeopardy was raised in the context of the cost orders and the findings by the Constitutional Court.
Yes.
And how can that all be relevant to 194, where accountability is being sought? These are not criminal proceedings.
No, there are. Double jeopardy can be separate proceedings. You know, for example, double jeopardy is raised in the context of labor relations, where I'm charged by my employer, which is happening here. And my employer charges me, and then I say, no, wait a minute. The theft for which you are charging me, I've already been charged for in the criminal court.
Yes.
That's the normal American concept of double jeopardy.
In other words, those proceedings, Mr. Mpofu, it's no bar to labor disciplinary proceedings that because there's criminal charges, you can't charge me internally.
No, it depends.
You can't go to the criminal court. Please listen. And you can't go to the criminal court and say, because I'm facing disciplinary proceedings at work, you can't charge me criminally.
No. It works the other way around. I mean, that's an extreme example. You obviously can't say that to the criminal court, but you can say that to your employer. It works the other way around. I forget the name of the cases. Something referral or something. But you can raise in the disciplinary proceedings at work.
Yes.
You can raise the obviously it's not a rule that has no exceptions, but you can raise the notion that let's suspend this DC process because I'm going to court next week and I might incriminate. Remember, both processes are under oath, so I might in giving evidence here in the disciplinary process, I might jeopardize my right to remain silent. Blah blah blah. The Lordship knows that. That's how double jeopardy applies, exactly because those proceedings are different. So the fact that those proceedings are different, the DC and the criminal, is not the answer.
Mr. Mpofu, with respect, that doesn't relate here because there are no other proceedings that are alive other than what is intended to be under the new rules.
No.
So the analogy of criminal proceedings and labor proceedings doesn't apply. We understood you to raise the issue of double jeopardy on the basis that because she had already faced proceedings in the Constitutional Court, there she had been sanctioned with cost orders, that she can't face a similar sanction through these processes.
No.
Now,
Okay.
is that the applicant's position?
Well, as far as that point is concerned, the simple point we are making, my lord, is that if you have been punished for a particular transgression,
Yes,
right, by the legal system. Now, in this case, remember that point is linked to the first point we make is that these things happened and the courts dealt with them. We debated that the other day. Here, the limited value of the submission was simply that when you have already been punished for something, that's just a normal principle of fairness. Double jeopardy means if I steal this thing and then I get punished for it, that's it. Then I am. That's why the Americans use it even deceptively, because somebody gets an acquittal and then they say there's video evidence of you actually committing the crime, and they say, well, there's nothing you can do because I've already been punished for that crime. So that's the notion of double jeopardy. It's unfair to the system, but it's fair to the broader.
You're not using American concepts here, Mr. Mpofu, with the greatest of respect. The proposition that you make is that because the Constitutional Court has made adverse findings against your client, has punished your client with personal cost orders, therefore she should not face another fate to these processes. How can that be constitutionally squared with the responsibilities under Section 194 of the Constitution?
It's the same as the criminal courts have a responsibility to lock up murderers, but that responsibility they have must be exercised within the Constitution. So you can't say, well, because you've been punished for a particular crime in another court, let's say in the magistrate court, and then now we find that you must be tried again for the same crime, then you say no, double jeopardy doesn't apply because whatever because it's the responsibility. It doesn't work like that way. If you've been tried once for the same thing, that's why I'm saying it's unfair. If you look at it narrowly in terms of the specific person, it looks unfair. But issue of administration of justice. It's a rule that says no person may be punished twice for the same thing. It's a simple rule that's based on that. The fact that it might operate fairly or unfairly in particular circumstances is neither here nor there. It's a rule. It's the same as, and that's where the res judicata thing comes as well.
Yes,
Similarly,
please explain that.
res judicata is a similar. It's how do you call it? A civil law cousin of the double jeopardy rule. And again, it means the same thing. Once an issue has been determined between the two parties, rightly or wrongly, doesn't matter. It cannot be determined again. And that must be distinguished between the so-called live issue. It doesn't come into it, because that's the distinction between lis pendens and res judicata. Those are two separate legal concepts. Lis pendens is about live proceedings. In other words, if there are live proceedings in another court, you cannot try the same. That's for different policy reasons, because two courts might come up with different judgments. But res judicata is to serve a different purpose, which is
res judicata. These are not the same parties involved. These are not the same parties. The res judicata, the issue before the Constitutional Court, were different parties to the issue before the National Assembly. How can the res judicata possibly apply in this matter? Is this a serious contention that this court has to deal with, res judicata?
No, it's a principle. It's a principle that we were saying it's like. The principle is not the res judicata. The principle is that you may not face consequences for the same action. So double jeopardy, that's why we said double jeopardy and the same principles as res judicata. So forget res judicata, let's talk about double jeopardy, because the principle is really what we're after here, once again. The principle is that you may not be punished twice for the same actus reus, for the same conduct. I don't know how to explain it. That's a principle of law. It has exceptions, I accept that. But to deny that there's a principle of law that says you may not be punished twice for the same thing, well, I don't know, I didn't understand my learned friends to be denying that. But if they do, then they are wrong, because there is such a principle. They can say it doesn't apply on these facts or whatever, that's a different matter. But the principle of law in every country, that you may not be punished twice, I just forget its Latin incarnation, you may not be punished twice for the same thing, is a universal principle of law.
How does it apply in this matter, Mr. Mpofu? How does it apply in this matter?
Okay, let us say the transgression that the DA wants to be punished is was in one of the cases. Take any case you like, a CX or SARS. Let's say the transgression is that a particular averment was made in one affidavit, and then it was in conflict with another averment in another affidavit. I'm making this up because I can't remember the effects of each of those cases. Then so that's the transgression, right? The actus reus is making conflicting statements. Let us then also assume, well, let's not assume because it's true. Let us acknowledge the fact that the Constitutional Court then says for that actus reus, you're going to pay punitive costs to the amount of R1 million. Again, I'm making it up. And that's done. What the principle of double jeopardy simply says is that no other agency of the same parties doesn't mean the same people, it means the state in its various incarnations. So no other agency of the state can punish you for that thing of paragraph 20 and paragraph 13. That is a general principle of law. We can debate until it's too late as to whether it applies in a particular case or not in a particular case, but that is an irrefragable principle of law everywhere in the world, that you cannot be punished twice for the same thing. How it then gets applied in a particular setting is a different matter. But one cannot say that the simple principle that for the same action you may not be punished twice is strange or unheard of.
Mr. Mpofu, you're correct. These principles are not in dispute. The question is whether it's relevant and applicable to this matter.
Well, it depends whether one thinks that removal from office is punitive or not. If it's punitive, then it's punitive. The word punitive derives from punish. In other words, it means it has been you've been punished, and you are also going to be punished again. Simple as that. That's what chapter meant in paragraph 138 of the EFF versus Speaker impeachment, to say that the removal of the president is punitive.
Yes.
So you face punitive consequences twice. Yes. That's double jeopardy.
Yes, Mr. Mpofu, fine. And then just the last issue is that there was a response to the striking out application by the parties. Is there anything that you want us to consider in the light of their response to your striking out application? Because there appears to be inconsistencies in what is being sought to be struck out and what is not sought to be struck out. Is there anything that you wish to add in fairness to you, because you were not given the fullest of time the last time?
No, it's fine, my lord.
You're still persisting with
I accepted my fate that both in terms of the striking out and the condemnation, which was not asked for, that those will be granted. The condemnation, at least in the DA, was not even asked for in the heads. But I understood the court to be saying it's fine. It will be granted.
I'm dealing with the strikeout, Mr. Mpofu. Are you accepting your fate? Are you accepting your fate on the strikeout, or do we still?
On all the preliminary points, I'm not. The point of a strikeout is to, among other things, to save the time of the court. So to discuss it at the end of the case is really what we were saying. For example, is that the affidavit of the speaker, like 80 pages before they deal with anything. They just give you the history blow by blow. What business is it of the speaker whether the charges are good or bad or whatever? That it was those kinds, but I don't think, in fairness, I don't think it's going to take us anywhere to raise the conduct of the other parties in this litigation, including the fact that we would not be here if the simple proposals we have made day in, day out, that there should be an amicable suspension of this thing, in which case Part B would have long been finished, maybe in March or February. But I'm convinced that it is not going to be fruitful to those. So we rely squarely on the papers as they are. And we say that we're not abandoning anything. Let me not be misunderstood. But we rely squarely on the papers as they stand to say that the interim relief should be granted because the grounds raised are likely to succeed, and there's no harm conceivable on the part of the speaker.
And then, Mr. Mpofu, very lastly, normally in the reply, the applicant gets the chance to respond to the respondents' submissions on cost. Now, we've read your submissions in paper, but of particular attention is that the DA seeks an order of cost against the applicant on an attorney-client scale. Is there anything you want to comment on that, sir?
Not particularly, but all I can say is that we've said what we have to say about the application and non-application of the bio-watch principle, which has also been affirmed by the Constitutional Court. So I won't bore the court about that. But as far as the DAs, we say that the audacity of the DA, which has insulted Ms. Mkhwebane and called her a spy, or and has hounded her from the beginning, as it is said in their letter, from the day that she was appointed, and called her all sorts of names. And last week, we attached a press statement, which they released last week only, in contempt of these proceedings, to say that Ms. Mkhwebane must be removed. She's a this and that and the other. We've brought that to the attention of this court. The court will do with it what it wishes to do. But for a party that has consistently done that, and not even during these proceedings, continued to insult Ms. Mkhwebane, to ask for attorney and client costs simply because we have said that the DA has an axe to grind, which it clearly does, is really very thick coming from them. And we're not saying by saying that, my lord, and I tried to explain again, it was one of those, I tried to explain this notion on the first day, that the DA is a political party. It is entitled, and then the word entitled was then, when I say entitled, I don't mean that it must do so. I'm saying that it can play politics, but it cannot ask this court to do its political bidding, so to speak. So it has a right to hate Ms. Mkhwebane, right, quote unquote. It can insult her. She's big enough to take them to court, as she did with the spy allegations and all that. It can say all sorts of all manner of things, yeah. But what it cannot, it must be able to Ms. Mkhwebane, unfortunately, it's like attacking a judge whom you know is not in a position to attack you back. Ms. Mkhwebane is not a politician. It's not as if the DA is attacking the IFP. The IFP, they can, and that's why we find it irresponsible that the Speaker justifies the actions of those members who have prejudged Ms. Mkhwebane. And it's done frivolously. The Speaker says, no, the members were just being robust. Robust against who? The members can be robust against each other because they have a right to insult each other in Parliament, and they can't even take each other to the civil courts. But they have no right to insult an outsider, a person who comes there as an outsider, and then tell you, no, you must resign, this, and the Speaker of all people, who is the custodian of the rules that have been flouted, comes to court under oath and says, just grow up. You know, the members are just being robust. Instead of saying, I will not tolerate in my house members who transgress Rule 88 and comment about a person whose removal is dependent on this house. That I will not tolerate. No, not only does she tolerate it, she condones it. She says, no, it's robustness. Robustness, please. So the DA that has participated in all those insults is the last to say that they are so hurt that this court must now come to their political aid in the fake, apprehension of damage which arises from Ms. Mkhwebane simply pointing out the truth that they've called her a spy falsely, and that she has taken those measures. So there's no basis whatsoever that should not even be entertained.
Mr. Impovu, is there anything else before we wrap up? We've now covered with you, Cos, the issues of double jeopardy, of res judicata, and some of the issues that the court wanted to raise with you. Need to get from my colleagues, Judge Steyn?
No questions, thank you.
Okay, so my colleagues are covered. I am covered, Mr. Wolf. Thank you. Is
My
anything
Lord,
else?
yes, just one small point. We're not going to, we had anticipated, of course, that the other point, okay, maybe let me just put it like this. Of the points that we have raised, which we have not argued now, those points remain on the table, except anything that we have specifically abandoned. So the point about sub judice, rule 89, we have not pursued it vigorously within either in our heads or in the oral submission, because we had anticipated that the ATM, because you remember that that was one of the issues that they had.
Did address it with us.
And Mr. Skagane did address it a bit.
Yes.
Yeah, all I'm saying is that that point is still alive, but so nothing should be read from the fact that I've not dealt with it. Other than that, my lord and my lady, I know that I speak for all my colleagues. I sincerely want to thank this court for its patience and the giving this matter the seriousness that it deserves, and giving us. On day one, I can reveal now that on day one, when I asked whether there's going to be time limits, I was ready to offer to stop at lunchtime. But when your lordship said we can go ahead, then of course that's the last thing counsel wants to hear. But on a serious note, I know that the court did that because it realized that this matter is of. If there's one thing that we all agree on with my learned friends, which was expressed in one of their letters, is that this matter raises serious and weighty and complex constitutional issues. And I can say that this court has approached it in that spirit. And therefore, we're headed to the court now.
Mr. Breitenbach, I see you are on your feet, literally.
Thankfully not literally, my lord. I would ask your indulgence for less than 5 minutes, probably 3 minutes, to do two things. The one is just to clear up what may be a slight point of confusion raised by something my learned friend said this afternoon in connection with a letter written by the Speaker on the 30th of January this year. And the second is to respond briefly to a series of factual submissions concerning the equivalence, contended equivalence between the facts in Gordon's case and the facts in the present case concerning irreparable harm. That was not a point made in my learned friend's main argument, but he says that the cases are, he seemed to backtrack from it eventually, that the cases are in pari materia, and I'd very briefly wish to just make submissions concerning the irreparable harm on both sides in that case as against this case.
Just get Mr. Jackson Miller just straight. Any objections? No. Okay, please proceed. 5 minutes you have, Mr.
I will be less than that, my lord.
Okay, I know you haven't asked me, but I have no objection.
Thank you, Mr. Gofer.
Well, I'm entitled to object as a matter of principle, but that's fine.
But thank you for not objecting.
My right of reply if there's something that he
yes,
raises.
certainly. Oh, absolutely. Mr. Breitenbach?
Thank you, my lords, my lady. My learned friend referred to a letter written on the 30th of January 2020. It occurs in the record in two places. The first is in volume 2 at pages 161 to 2. It's PFA 10. The second is in volume 6. It's at page 501 and 502. And it is the Speaker's response, personal response to the letter from, the first letter from the Public Protector's attorney. That letter related to Ms. Mazzoni's first motion. In other words, the one which was withdrawn on the 23rd of February 2020. And in it, she explains why she was not inclined to stop the process which that motion had set in train. My learned friend made certain submissions about the Speaker's acceptance of that motion. I understood him to imply, perhaps he wasn't intending to do so, that the acceptance of that motion or the reasons for it expressed in that letter are the same as the Speaker's reasons for accepting Ms. Mazzoni's second motion, which was tabled on the same day that she withdrew the first one, in other words, on the 23rd of February. Now, those reasons are given in the Speaker's answering affidavit. It's in volume 3 at pages 242 to 244. The decision in question was taken on the 26th of February, and it's paragraph 125. And they are detailed reasons. They're repeated in our heads, as I recall it, at paragraph 166. I did refer to them. All I wanted to clear up is that the reasons why the Speaker accepted the second motion are set out in detail in the answering affidavit. Turning to the second issue, we submit there are 2 points of distinction between the facts of Gordon's case and the facts of the present case concerning the irreparable harm on both sides. Firstly, in Gordon, there was no foreseeable irreparable harm to the public protector if the implementation of the remedial action in her report was suspended pending the outcome of Mr. Gordon's application for judicial review of the report. And in this regard, we refer the court to paragraphs 58, 60, 62, and 66 of the judgment of Justice Kampepe, the acting Deputy Chief Justice. Here, by contrast, the interim interdict will prevent the National Assembly from performing an important constitutional function for what could turn out to be many months. The parties have agreed on a hearing in late November, 3 months hence, and then obviously there will be a period where the court will have to consider its judgment. The second point of distinction relates to the other side of the scale. In Gordon's case, the foreseeable irreparable harm to Mr. Gordon's reputation and vocation arose from the implementation of the public protector's remedial action pending the outcome of the judicial review. Now, as His Lordship presiding pointed out to my learned friend this afternoon, the first element of that remedial action required the President to take disciplinary action within 30 days on the basis of the public protector's prejudicial findings against Mr. Gordon in the impugned report. And that is apparent from firstly paragraph 14 and footnote 7, to which His Lordship presiding referred, and also paragraph 67 of the judgment of the acting Deputy Chief Justice. Here, by contrast, the main sources of the harm to Advocate Mkhwebani's reputation are the trenchant criticisms by judges of the High Court and justices of the Constitutional Court of her performance of investigations and her conduct in proceedings for judicial review of her reports. In the case of the CIEX matter, those judicial review proceedings, including the issue of costs, have been finally concluded. Ironically, Advocate Mkhwebani evidently believes the judge's criticisms of her were unjustified and incorrect. I say ironically because the Section 194 process initiated by Ms. Mazzoni's motion, which Advocate Mkhwebani is now seeking to interdict, offers Advocate Mkhwebani the opportunity to defend her conduct and to remedy the harm to her reputation caused by those adverse judicial comments. Thank you, my lords and my lady.
Thank you. Mr. Mpofu, you have a right of reply.
Okay, well, the first one is really Mr. Breitenbach. Just give him a word of advice. He must not look a gift horse in the mouth. When you are abandoning the issue of the reasons in respect That's exactly what we're doing, because if you look, if he must just read carefully the prayer that we're abandoning, prayer 5. Says, directing the speaker to furnish with requested reasons for the approval decision made announced on 24 January 2020. That's the first motion. That's one of the reasons why that is. And we had said that we would amend that to cover this, but we're saying we're abandoning it in total. So he should be thanking me, not objecting. The next issue is in his justification, he's just putting his foot in it, because you can't tell. I mean, what kind of audacity and temerity do we have where a speaker can say, "I'm not going to give you reasons. You'll find them in my answering affidavit," which is what Mr. Breitenbach is telling us. Really? This is what Lord Denning had to say. The giving of reasons is one of the fundamentals of good administration. And it says, the significance of a duty to give reasons goes well beyond the procedural benefits. These are substantive benefits, for the duty can improve the quality of the decision itself. The presence of such duty helps to concentrate the administrator's mind on what is relevant, and that leads to a more rational decision making. There's no better illustration of that than here. If the speaker had given us the reasons, her decision would have been more rational, because we would have told her, for example, I said this last time, that it cannot apply retrospectively. So let's not go there, because the reasons that are in an answering affidavit are not reasons as contemplated in our law. Now, the second point that he makes, that the facts of Kodan are different from the facts of this case, I've long considered that, insofar as you can call it a concession. The point that we make with the Kodan case is that the harm. I mean, I thought Mr. Breitenbach was going to favor us with an answer to the question I've been asking for weeks now. What is the harm to the speaker? That's why I was not objecting. But it comes with other things. There's no harm to the speaker. And it doesn't matter if the harm facing disciplinary proceedings before the president is different from facing disciplinary proceedings before the National Assembly. Of course it is. But they are both facing disciplinary proceedings. I mean, are we going to argue at that level now of saying the disciplinary proceedings before X are different from disciplinary proceedings before Y? Really? The harm that is envisaged in Kodan is, in EFF versus Kodan, is the harm of facing the disciplinary action and facing a parliamentary committee, which is happening in this case, especially when it is weighed against zero harm to the speaker. As I said, even if you put 1 milligram against zero, the milligram will be heavier, because zero is zero. The issue, the last point, I mean, now we must say, because in that case, they were facing disciplinary actions within 30 days, and here is within 6 months. So what? The last point in this is that Mr. Breitenbach really makes a serious mistake, and I didn't want to address this. It is not the role of the speaker to tell this court, as they've been doing ad nauseum, in 80 pages of their founding affidavit, in 2.5 hours of their address to this court, and now in this extra time that Mr. Breitenbach had, to tell this court that Ms. Mkhwebane is guilty or is a bad person. Yeah, let's assume she's very guilty 1,000 times. That's not the point. We are talking about the constitutionality. You know, I always say this to students. If you ask anyone about S versus Makwanyane, the so-called death penalty case, none of us as lawyers even remember what Mr. Makwanyane did or didn't do. He could have killed one person or 1,000 people. The court was busy with defining the rules as to whether or not the Constitution allows the death penalty or not. You couldn't argue that case by saying, no, but Mr. Makwanyane has killed 1 million people or 2 people. It doesn't matter. The constitutionality of what we're debating here and in Part B has got absolutely nothing to do, let alone the inappropriateness of the speaker giving pages and pages about whether in CX this was this and that and that. That's not her business. The business is about due process. This is the question we face here, insofar as that issue is concerned, and then procedural unfairness. So fortunately, all these cases we deal with here, I was involved in them. Nkandla, UDM case, EFF speaker case, impeachment, and even the president's challenge in the full bench of the. In those cases, this was not the issue. We sat there and debated. It was not whether Mr. Zuma is so bad that he built some house in Nkandla or what. The question was whether the rules of parliament, as they stood, were appropriate for his impeachment, yes or no. And the court found that they were not, and he could not be impeached on that ground. Whether he had built 1 million Nkandlas or 2 or 1 is mightily irrelevant to the question that is before this court. So we don't want to be, exhausted with, submissions about, no, she did this, she did that, it was bad, and courts found that. Even in the Zuma case, the court had actually found that the president had violated the Constitution. There can't be anything worse than that. That's bad enough, but the court still said you cannot impeach him until you have valid rules that pass constitutional muster. So Mr. Bredenbach must just relax about the question of guilt or not guilt will be dealt with the day there are rules that are compliant with the Constitution. Then we will be there. You can be sure that the public protector will be equal to the task of facing everything that the DA can throw at her, whether it happened 100 years ago or not. But we're not busy with that now. We're busy with whether the rules in respect of which that guilt or not guilt is to be found are constitutional, meet our Constitution. Full stop.
Thank you, Mr. Mpofu. Is that all?
That's all, Melo.
Good. That's Dr. Melo. Anything else? Good. Well, this brings us to Mr. Breitenbach, Ms. Bauer, Mr. Motsepe, and Mr. Vassen. Good. So this brings us to the end of the proceedings and the argument. We will now reserve.
Not mine.
Somebody's mic's on. So now the judgment is reserved. It's just for the court to thank the parties for the and it's to thank the parties for their presentations. As you see, Mr. Mpofu, here in the Western Cape, we debate robustly.
We must remove Parliament from there, I think.
Yes, no, we debate robustly, and we thank you in particular for being prepared to engage with the court on, as you correctly point out, are very important issues.
I'm indebted to the court, my lord, and my learned friends.
Yes, and there's absolutely nothing personal about it. Is that in the debate, the court attempts to get clarity on some of the issues that the party has raised in this matter. So I can speak on behalf of both my colleagues that the debate has taken place in that spirit. It's really for us to understand and to assist the court at the end of the day in arriving at a just decision. So thank you for your engagement with the court. Thank you to the other parties, Mr. Breitenbach, Ms. Bauer, Mr. Motsepi on behalf of Mr. Sigakane and Ms. Blizzard, if you're still with us, to thank Mr. Buttender for the engagement with the court. All of this has certainly been very useful and very helpful for us. And then lastly, just to thank all the other people who have been a part of this virtual hearing over the past couple of days and all the mishaps we've had. Once again, an apology from our side for having delayed this. This is new technology and hopefully we'll get it right in due course. Today it's worked well and it shows that we can improve on this. But to all of those who've had an interest in the matter, who've joined our presentation, we've counted at times in excess of 37 people who've been participating and watching. We thank them for their interest in the matter. So with that, we adjourned and judgment is reserved. Thank you, everybody. We are now done.
Thank you, my lord.
As the court pleases, ma'am.
Good, thank you.
Adjourned.